business council, I am waiting with an item of 47 last item. They will get clear to the register order, as well as the appellate order, and to produce the requirement. Though it is not reflected in the order, but earlier one of the people directed to produce the requirement. Record is not available in the
Right, you produce it. Item 47 at the request of Mr. K.K. Porako. Learned CEC, matter stand adjourned for every wanted. Let it come in the, it should normally come to the hearing list.
daily hearings.
Part two. This is what termination. Termination. All right, for the time being, let it be
Yes.
after 2 weeks. Yes.
If you go to item number 7 of the review, and it's later to the agent of the week.
7.
Yes, sir.
Why?
We need some instruction from our client. We are able to contact
Item 7 at the request of Mr.
S.A. Borbu.
S.A. Borboya might extend the adjourned for 2 weeks.
If you.
Is a lordship. Lordship, item number 27, we are the respondent lordship. Actually, we are filed an affidavit in operation. There is a mistake in the designation of the affidavit lordship and they allow me to rectify it.
It is already filed.
Yes.
Filed when? Let the matter come up, you tell us. Let the matter come up, you tell us. Yes.
Rejected by his honorable court.
Bail.
Rejected by his honorable court, Your Honor. Can he use the unlisted method?
Not unlisted. How can it be unlisted? Second bail.
We expect today, tomorrow itself.
Expired what?
We expect tomorrow itself.
Huh? What is expired?
It's a very period.
Let it be. We are not giving unlisted. You file it, it will come on its own, second bail. You file it, it will come on its own.
Next reason. Next reason.
Yes.
I would like to mention item number 40 is supplementary matter. If negative is after
48, I don't know why it was fixed today.
one of the, this is vacancy related.
Let it come, let it come. It is fixed matter motion. Wait for your turn. Yes.
Before listing of 5 new motion matters of lordship on Monday.
Why?
Services have been terminated.
Like termination, all right. You file it, it will come on its own. If it doesn't come, you make a mention.
Therefore, listing also, but at least so. Letting not suspension. Last question, 21. There's a better list.
All right, at least in September. Will come in September.
What date? 11 September. 11 September. I'll get them before.
No, 11. 11 September. Yes. Yes, yes, yes.
Daily list, item number 1.
Yes.
Suspension matter. In the last one, that is on the plan. In the similar circumstances, this honorable court.
Judgment is not here.
Well, I have some right to be.
It is not here. What is the, give us a citation.
That activity. Regarding any judgment of our high court. It will be the other citizens this week. Paragraph 7 of this judgment. And direction part is paragraph 9. 9 and 3.
What is the status of Rafid Ali? It was review or appeal or something was filed.
The lordship after Rapidly, there is another judgment.
Ah.
In Prasanta Gupta, asking the month of June, 2023.
Where it was referred to larger bench.
No, your lordship. The Rapidly was discussing this particular matter, because in his case, he is contending in this particular judgment in terms of paragraph number 7 and 8. In that case, your lordship, one of charges were not issued, but in his case, disciplinary proceedings have started, inquiring officer has been appointed, presenting officer has been appointed. And because of that, in the pendency of the disciplinary proceeding, his suspension could not be reviewed. We have received the paragraph from, let us find the
What is the judgment you are referring to?
Prasanta.
What is it? What is it?
If
What
otherwise,
what is the ratio there?
It's citation.
What is the ratio in the judgment?
Ratio basically, because in this case also disciplinary proceedings has started. And when the next time he appeared, Mr. Arthur appeared in that particular case. And the honorable court directed the respondents to complete the disciplinary proceeding and continue with the suspension.
No, but if it is covered by division bench, it is covered by division bench. It's binding on us. Rafid Ali Ahmed,
Yes, sure. Even rapidly also, the last paragraph was mentioned to continue with the department, so then likes to pursue the department proceeding, they can and again review the suspension. Based on Ajit Sanwal. That was also a division bench. But in this case, was no review has been done. And departmental procedure has been known after filing this petition. No, that is not what he himself annexed the so-called notice in his own petition.
he says it is filed after the writ petition.
No, page number.
Well, let you bring it on record, we'll see. Our learned counsel to the parties, Mr. D. Vora, learned government advocate, submits that comments have been received, he tried to file it for reply. Placed after 2 weeks, enabling him to file the reply. Mr. M. Khan for the petition. When you file the reply there,
Department of Proceeding, there is no Department of Proceeding within 90 days. After that, you also
so therefore it will require examination of the judgments passed by this court with reference to Ajay Chaudhary. Therefore, let them file the affidavit to bring whatever they want to say on record. We'll take it up. After 2 weeks, it will come. Let them file the affidavit, you are entitled to make a mention after that.
Item number 2.
Yes, Mr. Gupta. Yes.
Please take order dated 28/7.
He has instructions.
Yes, we have received instruction, Mother, school file the agreement, but I would have got the private from.
What is the instruction?
Instruction says, my lord, it is further order the selection committee there was insufficient experience of the applicant and after the meeting could not proceed in future. And also one of the, that's why one of the, this affidavit to the brought to the airport, one of the, another one of the, one of. Two time maybe that matter I will file it.
So you'll file, but I want to know what instructions you'd like to bring on record.
My instruction is, my lord, this is the SCR submitted, insufficient SCR of the applicant. So SCR is to be considered for promotion.
But this is what they're saying. They are already making a statement that because of insufficient ACRs, it could not be completed.
Whether in 2019, they say there is insufficient efforts, so they have to within a 1 month, that should be produced. Now it's more than, well, almost more or less 4 years. 1 month hasn't come.
All right, they have received instructions, let them file. Heard learned counsel to the parties, Mr. T. Sutia, learned government advocate, praise for and is granted to be time to file the counter affidavit as it is submitted that instructions have been received. This is after 2 weeks.
Item number 3.
Considering this matter, I don't consider it on late, so the kind of matter will pass for time period.
Not timely. Next week. The request for council. Matter adjourned next week. Next week.
The watcher of matter is slightly urgent, the watcher there is two cause.
If it is urgent, you argue.
I can argue, Watcher.
You argue.
Signal is-
Either you argue or we pass it over, no passing over today. Yes.
Watcher the petitioner.
Hmm.
Single computer typist Watcher. Working for the establishment of the district and sessions judge Nogam. If you watch it, kindly come to page 22 and 23 for the matter. Your Worship.
Yes.
On the 3rd of January this year, Your Worship, the petitioner was suspended with immediate effect. Thereafter, that suspension letter, Your Worship, the order was further extended for another 3 months. The basis, Your Worship, for the suspension notices. If Your Worship can kindly come to annexure D, Your Worship, page 25.
Hmm.
Page 25, Your Worship.
Yes.
There are two anonymous complaints which have been filed against the petitioner. The first complaint is at page 25, before Your Lordship, which is dated 1st of January 2023. If Your Lordship comes to page 27, Your Lordship will see that identification has not been disclosed. At page 27,
Hmm. Is there a circular?
there is circular, Your Lordship. The
Where is that?
circular, Your Lordship, is at page 41, which has been issued by the Registrar of Vigilance of the Guwahati High Court. Point A states that the complaint making allegations against members of the subordinate judiciary in the state should not be entertained and no action should be taken thereon unless it is accompanied by a duly sworn affidavit and or verifiable material to substantiate the allegations made therein.
He is working as what?
The computer typist,
It's not a subordinate judiciary.
is an officer subordinate judiciary.
No, but this is meant for a subordinate judiciary.
Yes, sir.
He's not a member of the judiciary.
You remember the subordinate judiciary is capacity as an officer of the person.
No, he's a staff.
He's a staff, he's a staff. And that is, this is very applicable.
No, doesn't say so. It's only with regard to subordinate judiciary, not against the staff. You may say that yes, the same principle should be applied for staff.
In fact, actually omitted the watcher.
Hmm.
This was a second notification. The first notification, this circular itself was provided by my learned friend, dealing for the Guwahati High Court project, that this is very applicable to the petition. When notice was issued in the earlier matter,
Hmm.
the suspension was revoked, he was made to be reinstated. And on 16th, the watcher was transferred to a separate station.
Where is that earlier order?
The earlier order, your watcher can be see page 49, your watcher. Page 49. Page 49, your watcher, is the first notification. Notice was issued. It was page 50 here.
This matter is still pending.
No, your watcher, we have withdrawn the matter because the matter was impetuous. When your watcher, the notice was issued on 15th. Thereafter, your watcher,
Why did you withdraw the matter?
your watcher, the prayer in the petition, in that petition was for challenging the suspension order. The suspension order was revoked, was reinstated. And thereafter, on 16th, your watcher was transferred.
Then he was again placed under suspension.
No, he's not based on a suspension reports, but we're challenging the entire gambit of the departmental proceeding reports. Which finds its basis on the basis supposed to be another Sunday.
Then we issue notice at this stage.
If you watch it at this point in time, you can kindly provide some interim cover area, watch it and get the reports and see the.
What interim do you want? What is the stage of the proceedings?
Yeah, the show called charge sheet was issued, the watcher to kindly come to page 63.
You respond to the charge sheet. You respond to the charges. Let them file their reply, we'll take it up.
What is happening, what we see is that there is a pattern of behavior here, that was additional. After you get this first one.
No, first writ petition you file only for assailing the suspension,
Yes,
not the challenge, not the DP.
not the DP itself. That was never referred to in the notice, that was some mission on our part. Thereafter, he was reinstated in notice.
Constructive res judicata.
Then the motion, the subject matter was only the suspension order.
You chose not to challenge. Why was he suspended? Pending, where is the suspension order?
The notice come to page 23. Suspension orders.
22,
Yes, the first connection, area.
then 23.
23 is the subsequent. Is further extended the period of suspension.
So this was also challenged.
This was
No. No, like we'll issue notice at this stage. Let them file their response. And what is the challenge made in your writ petition?
yes,
You are submitting that this circular is applicable to
yes,
the staff also.
yes. This was what was submitted in the earlier notification by my learning.
Where is it? Where is it recorded?
My lordship, we have not submitted.
Where is it recorded?
Yes, your lordship, kindly come to page 8, your lordship, paragraph number 9.
No, that's a statement you made, but was it recorded in some order?
No, your lordship. In fact, the notice was issued on the second day when the matter was heard. Then the honorable court directed that if there is any circular which covers the service conditions of petitioner, it can be furnished from the honorable court. Thereafter, this matter came up on the where my learned senior attorney responded, your lordship, to furnish that copy of the way.
Is it mentioned anywhere from in the OM that which is applicable?
No, lordship. In fact, in this one is not applicable. So there is another one that is attached in the petition itself.
Page number?
Yes, your lordship, you kindly see. Page number 30. Page 30.
30.
Yes, your lordship. Page 30, which is the annexure E, your lordship. Guidelines regarding handling of complaints in the Ministry's department.
Yes.
Yes, the undersigned is directed to say that instructions regarding dealing with anonymous and pseudonymous complaints were issued by this department's office memorandum of even number dated so and so, prescribing that no action is required to be taken on anonymous complaint, irrespective of the nature of the allegations, that such complaints need to be simply filed. Subsequently, the office memorandum has been clarified by OM of even number dated so and so. In this regard, the Central Vigilance Commission circular dated so and so may also be referred to. The copy of each of the DOTs requested. This is the list of the going about. In fact, the applicability of this way was also argued, your lordship, which is reflected at page 33 of it. Before this honorable High Court. So, matter basically, your lordship, this is my submission before this court. The matter basically, your lordship, is an anonymous complaint, where it is explicitly stated that the distributor of the complaint cannot be distributed. That we got that really, your lordship, when the records come to the next day, your lordship will stay the record. The great for employee.
Let them get their affidavits. We'll file it.
In fact,
Because
your lordship, just one more aspect I like to highlight with honorable court. The lordship would kindly down to page 60 here, page 60 for a moment. Page 60. Page 60 is the order which was passed on the 14th, where the second order was revoked. He joined the office on the 16th, your lordship, at 6 o'clock. The transfer order was issued. Your lordship. This is ample.
what are you now challenging? Transfer or
I'm trying to transfer order, your lordship, also. Because this is not a mere instance of surveillance in this matter, but there is a selective and vindictive activity you want to take.
We'll see about
But that is subject to
We'll
your
see
lordship's final determination, your lordship. As of now, I'm very lordship, till the affidavit is filed. There is no difficulty which will be caused by the respondent's lordship. I'm still serving with the office.
No, that's all right. Once they have issued, we can pass appropriate orders after the records or whatever is necessary. If they want to file, let them file. We'll go for a hearing. We can't give an interim order suspecting a DP. And then returning a finding that yes, DP may continue now. Let it continue. We let them file their affidavits. We'll pass necessary orders as and when the affidavit is filed. Heard when it comes to both the parties, this petition is filed with the petitioner. Putting to challenge the show cause notice dated 22/05/23. Oma charge sheet
Period 36.
dated 30/06/2023, as well as the transfer order dated 16/6/2023. Issued by the respondents to the petitioner. So petitioner is presently working as a what typist?
Computer typist.
Computer typist,
They established the respondent.
and is presently posted under the respondent number 3. There are counsel for the petitioner referring to the, where is that?
When you watch at page 41,
Referring to the OM
dated 27/3/2017.
dated 27/3/2017
17.
submits that the OM issued by the Registrar of Vigilance, Guwahati High Court, reflects that anonymous complaints should not be proceeded with unless it is accompanied by a duly sworn affidavit or verifiable material. Don't put anonymous, say complaints making allegations against members of judiciary should not be entertained unless accompanied by duly sworn affidavit or verifiable material to substantiate the allegations made there. And any action to be taken on such complaints shall be only after the satisfaction of the competent authority designated by the Chief Justice of the High Court. Stop. Learned counsel for the petitioner submits that this notification is equally applicable to the staff working under the subordinate judiciary. And therefore, the complaints being anonymous and not supported by affidavit, no action could have been taken by the respondents initiating disciplinary proceedings. Stop that apart. And counsel for the petitioner refers to the OM dated 4th February 2020, whereby issued by the Government of Assam Departmental Personnel within bracket B.
In fact, your lordship, the relevant OM is at page 30, your lordship. It is OM dated 8/10.
Sorry. For OM dated 8th of October 2018, issued by Government of India, Ministry of Personnel, Public Grievances and Pension, where it is stated that no action is to be taken on the basis of anonymous complaints, irrespective of the nature of allegations. Stop. Current counsel for the petitioner submits that in view of these circulars, the spirit of these circulars will be applicable to all government servants, including the petitioner, and therefore the DP initiated on the basis of anonymous complaints is bad and needs to be suitably interfered with. Mr.
And just for
N.K. Sharma, learned counsel, appearing for respondents 2 and 3. Submits that would like to obtain instructions and file necessary affidavits by Mr. D. Bora for respond, appears for respondent number 1. Stop having heard learned counsels from the parties. Let the respondents respond to the contentions raised in the petition by filing affidavit so advised. That notice issued, returnable 4 weeks. Since standing councils represent respondents, notices a week, however, extra copies be furnished within 1 week from today. Stop. The authorities may proceed. The DP proceeded against the petitioner. In the DP proceeded against the petitioner. No final orders will be passed till the next day fixed.
In this matter, Lordship, this is UOPT circular. It is not applicable.
You file your affidavit, argue the matter. Let the matter be listed again on. We give 4 weeks, so 11th September.
I'm grateful.
Item number 4. When it took the petitioners hearing are the candidates who applied for the Ongarwadi workers in the year 2009 membership, and they are the local residents of the Ongarwadi Center membership. Next of this petitioners filed by the petitioner challenging the order dated 28/4/2023, which is annexed 12 at page number 135. The reviewing order has been passed in pursuant to the order dated 9/1/2023 passed by this Honorable High Court. My Lordship, in a joint petition. May I kindly see page number 135?
135.
Yes.
Yes.
If the order has been passed by the Lordship Director of Women and Child Development, Assam, my Lordship, please come to page number 136, bottom of the line, my Lordship.
Yes.
Very good. Whereas the CDPO Kalai has submitted verification report by letter number 2023 in report of this CDPO Kalai, it is reflected that the respondents namely Fatima de Lashkar, Shilpi Nath, Yara Begum, Krishna Begum, Ranjana Vaishnav, Krishna Vaishnav, Farma Begum, Aradida belong to the revenue village where the concerned AWC is located at the time of appearing in the interview. Thus, as per the extent, well, it should be existing government guidelines, they are eligible to be selected as Anganwadi worker. We have challenged this portion, my Lordship. This order has been passed in pursuant to the order dated 9/1/2023, which is at page number 120.
This order is in favor of respondent 678.
Yes, my Lordship.
All right.
Kindly, your Lordship, probably Lordship to page number 120, my Lordship. The joint order passed in petition number 79.
Yeah, the order was passed. What was the direction in the order?
Page number 120, my Lordship. Related to page number 129. Para number 2 of this order in page number 129, my Lord.
It was a direction pass.
Yes, my Lord. Direction at page number 130. One thirty.
Hmm.
132, my Lord. Para number 6, my Lord. There are 6, my Lordship, in the Mr. P.K. Chaudhary, Learned Counsel for the petitioners in WPC number 4051, make a submission.
So the pursuant to the direction, they made an inquiry. They were found to be residents.
Yeah.
So what is wrong with the order?
My Lordship, in the year 2009, there was an advertisement, my Lordship. In the guideline, it says that they must be from the Anganwadi Center, residents of the Anganwadi Center, not revenue village. My Lordship, even in the order, it clearly says that the territorial jurisdiction of the Anganwadi Center. But while passing this improving order, my Lordship, they have given the revenue village, priority to the revenue village. But in the year 2009 and 10, in both the guidelines, the revenue village was not there. It was only for the territorial jurisdiction of the Anganwadi center. The petitioner herein belongs to.
No, it says revenue village where the center is located.
Okay.
The center has to be located somewhere. So it has to be located in a village. It is located in some village.
My lordship, the residents must be within the center, my lordship.
What is the meaning of within the center?
My lordship, kindly see page number.
Does it mean that they have to reside in the center?
My lordship, there is a survey area within the survey, this area, my lordship, there is a survey area.
Mr. Counsel, don't make arguments like that.
I'm sorry.
The Anganwadi center is in some village
Yes, my lord.
or in some taluk. The taluk is in some related to some revenue village.
Yes, sir.
So once it is in a village,
My lordship.
unless there is a specification by the department that we will only appoint people who reside within 100 meters of the center.
Yes, my lord.
The fact that you are a local resident means a local resident of the village. You satisfy the requirement. That is what the report says. That their residents, they belong to the revenue village where the center is located.
My
Then
lordship,
what else? What is the direction of the court? Direction of the court is to make a factual inquiry. And if there in fact residents within the territorial jurisdiction of the rest, what is the meaning of territorial jurisdiction?
my lordship, what is my lordship? I would like to take my lordship, page number 30, my lordship. The previous guidelines, my lordship, is given by the department itself in the advertisement.
Yes, 30. Yes,
I'm sorry, my lordship, page number 28, my lordship. In 2009 guidelines. passed.
yes. What is the guideline? What is the guideline?
The candidate for the post of Anganwadi worker and Anganwadi helper shall be a local woman residing in the same area where the Anganwadi center is located.
What is the meaning of that? What is the meaning of a local area? Where is it defined?
My lordship, and there is a survey area also, my lordship. This local area means, my lordship, where within this area, the residents.
Do you want me to dismiss it today or you want me to issue a notice? Heard learned counsel for the parties, issue notice, returnable 4 weeks, take steps on the respondents not represented by the counsel within 1 week from today.
I am for only 1, 2, 3.
Mr. Sutia appears for respondents 1 and 3. Government advocates appearing for the respondents, we serve with extra copies within 1 week from today. Steps by registered post on private respondents. 1 week from today.
Item number 5.
Yes,
This matter relating to children to the select list of village admin, my lord. And the select list is at page number 84, my lord. Private respondent is selected, but till then no appointment has been made. My lord, advertisement.
now who is the appellate authority?
Appellate authority, my lord, I have already filed my appeal, my lord.
Any, what is the,
Divisional commissioner, my lord.
what is the order passed?
In the appellate authority, till date, my appeal has been live pending, my lord. Now, my lord, the appellate authority, my lord, the principal secretary is DAT.
So you transfer that to before the GAD. Yes.
Process is going on. Some of the suit, one of the appeal was pending before the.
Recently, I have inquired, my lord. My appeal is lying unattended in the office of the commissioner, the divisional commissioner.
We'll direct them to place it before GAD.
And there is another fair, my lord, in the interim, as the appointment has not been made without verifying the allegations, my lord, no appointment may be made. And similar order has already been passed by the honorable body. Many petitions, my lord. Then observation, otherwise they will made appointment, therefore another round of petition will be arrived.
Principal Secretary GAD. Heard learned counsel for the parties. This petition has been filed by the petitioner challenging the selection of the private respondent number
7.
7, so and so number, who was selected for being appointed to the post of Gaon Pradhan of lot number 2, Autodrova Moza under Ding Revenue Circle, District Nogam. Learned counsel for the petitioner submits that the respondent number 7 does not satisfy the required criteria of owning landed property in his name within the lot area. However, merely on the ground that is related to a former governor, his selection was considered, overlooking the qualification or the candidature, overlooking the candidature of the petitioner. So the petitioner satisfies all the requirements specified for being appointed as a governor. He owns landed property within the lot. So agreed by the selection made by the respective authority. And where is the select list?
Select list as page number 84. This is the type of my lord. And
What is 83?
83, my lord. 83 is the calling letter. That is
What is the date of the select list?
select list. This is on the same day, my lord. In the 85 page number 85, my lord. But no, there is mentioned here, my lord. So,
In the selection conducted by the authorities,
it is published on 11/3, my lord.
which is stated to have been published on 11/3, the name of the private respondent was shown to be selected. So they agreed the petitioner approached the appellate authority prescribed under the executive instructions
162
What?
C of executive instruction.
162
C
C
of
of the executive instructions appended to the Assam Land and Revenue Regulations before the divisional commission stopped. However, the appeal which was preferred by the petitioner has remained pending and no orders have been passed. Agreed the petitioner is before this court. Mr. J. Hendick appearing for respondent number 1 and Mr. R. Hall appearing for 2 to 6 submits that there is a change in respect to the divisional authority prescribed earlier under the executive instruction 162 C. Stop. Now, in place of the respondent number 6, the divisional commissioner, it is the principal secretary, the General Administration Department, Government of Assam, who has been notified. Has it been notified? Notified. You have seen it. You have seen that notification.
Here it is asset of the existing divisional commission establishment and the power of the administrative power as exercised by the divisional commissioner. Present will be able to by exercised by the commissioner and secretary of the principal secretary of general affairs.
Notification number.
Number which is 304149.
304149
/1
dated 17/7/2023 issued by the
my lord, the principal secretary of the government of general affairs.
issued by the principal secretary, Government of Assam, GAD. Whereby to repeat which will be silent. Whereby the powers exercised earlier by the division commissioner has been are now being exercised by the principal secretary GAD Government of Principal Secretary Government of Assam GAD. Stop. And all pending appeals, it is submitted that all pending appeals before the divisional commissioner are being looked into by the office of the GAD, office of the principal secretary GAD. So learned counsel for the petitioner submits that to the best of his information received from reliable sources, the appeal preferred by the petitioner is still lying unattended before the office of the Division Commissioner, Central Assam, Central Division Assam. Stop. In view of, you give us a copy of the notification. In view of the notification dated so and so, which is placed before this court by the learned Governor Advocate Mr. Henry. The powers earlier handled by Divisional Commissioner are now being handled by the GAD, Principal Secretary GAD. Notification reaches under portfolio notification. So, in that view of the matter, the petition is closed with the direction to the respondent number 6, as well as the respondent number 2, to place the appeal stated to have been preferred by the petitioner before the prescribed authority under so and so notification, namely Principal Secretary GAD. Stop. The Principal Secretary GAD will thereafter decide the appeal preferred by the petitioner. And do you have an appeal number or something?
No,
Where is the appeal? Have you enclosed?
98, my lord.
98.
Because we say on 8/5/2023.
98. The said appeal preferred by the petitioner on 8/5/2023 and stated to have been received by the competent authority on the same day will be decided by the Principal Secretary GAD within a period of 60 days. 60 days. Stop. The appeal will be disposed of by speaking order. Any order that will be passed shall, copy thereof shall be served on the writ petition. Stop. Since it is submitted that the appointment orders in respect of respondent number 7 has not yet been issued, the same shall not be issued if not already issued, till the appeal as directed is decided and disposed of by the Principal Secretary, Government of Assam GAD. The petition stands disposed of in terms of the above directions. About 60 days from the date of receipt of the certified copy of the appointment.
Item number 6.
Yeah, please answer. Father to work as a night officer under the state of and died on 28/6/2016. That within the time the petitioner applied for minor and subsequently minor the petitioner come before the honorable court and the honorable court passed the order by the page number 27 minor.
Yes.
Thereafter, the case of the petitioner minor was played before the DLC in 4 occasions, my lord, and all the times, my lord, it has been kept pending due to lack of vacancy, my lord. My lord.
So it can be treated to reconsidered on in eternity.
So, my lord.
Vacancies are not there.
Now, the petitioner before your lordship, to transfer the case of the petitioner from DLC to Walpara to our home district, my lord.
Well,
At that time of my lord, when it applied for my lord, that time there was no DLC in the newly created district South Charmara, my lord, Marcus of South.
no.
For the first time in 2022, my lord, it was held, my lord. And my lord, since 2017, petitioners.
You want the transfer to which area?
My lord, South Charmara district, newly created.
District.
My lord, petition also came to know, my lord, there are available vacancies lying, my lord. And since 2017, my lord, this case is pending. And it is kept pending, my lord, in the.
Why is it kept pending since 2000?
My lord, yes, my lord. Considered, my lord, and Yes, my lord, should not be finalized for want of requisite grounds of vacancies and kept pending for next DLC.
Where is that?
My lord, page number 32, lordship. Page number 32, it is the DLC of 21/8/2017. My lord, page number 32, last para, my last line is mine. The proposal of Srimati Kulesa Party, daughter of village Uruzaman Sheikh, could not be finalized for want of requisite norms of vacancy position and kept pending for next days. Therefore, my lord, it was placed.
This was in 2017.
Yes, my lord.
Yes.
But subsequently, my lord, place number 34.
What is the direction of the judgment of this court?
My lord,
Guidelines,
yes,
Mr. Hazurian? Guidelines? For how many years it is to be considered?
my lord, in the year 2022 also my case is placed before the DLC. My lord. My lord, page number 37, my lord. Thank you.
Correct, but if it is not there, it is not there.
My lord, page number, relevant page number 38, because the DLC, my lord, 3/8/2022. My lord, relevant part, first paragraph, my lord, here along with the petitioner's others also, my lord, my. serial number, my lord,
It is to be considered by the concerned DLC, district level.
Done on 4 occasions.
Huh?
He's done on 4 occasions.
No, he says South Salbara is the district now.
My lord, my
Newly created.
my application, my lord, annex 10, my lord, page number 39. Yes, I think no,
When was the district created?
my lord, 2015, my lord, but there was no any DLC was constituted. And the petitioner, my lord, petitioner's father was under the executive engineer, my lord, mechanical division, Gwalpara. My lord, my application is case number 39,
It is to be considered by which district?
my lord,
Your father was working under Gwalpara.
Gwalpara. Posting at Hatsini, what is created.
Maybe. So your office will be Gwalpara, you have filed it before Gwalpara. You have filed it before Gwalpara.
Yes.
That,
I was, my lord, the application was filed before the DLC Gwalpara.
notification from 1/6.
My case is not rejected by the DLC Gwalpara, my lord.
What does the notification say?
Since my lord, there was no any DLC in my home district, integrated home district, I could not apply for. Now, my lord, I am praying before your lordship to transfer my pending case, application for completion ground, my lord, to the DLC of my home district, my lord. I have to thank you, know, my lord, there are available vacancies also there, my lord. For the use of justice, my lord, otherwise petitioner will not be considered, my lord, and if we go on, my lord, case pending, my.
Clause number 6 says you have to file it in the office where your father was working.
Yes, my lord, my father was working at Shini, my lord.
So it is considered by the DLC of that area.
That ever at that time, there was no any DLC, my lord.
No, not Hatsini Mari. You're under the office of Gwalpara.
Gwalpara, right.
So it was submitted to Gwalpara.
Gwalpara, I have already submitted.
So it was considered.
It has been considered but kept pending, my lord, due to want of vacancy, my lord. My lord, how long, my lord, my case will be kept pending, my lord?
We'll direct them to reject it.
My lord, since my lord,
If you are unhappy that it is kept pending.
my lord, already in our home district, my lord, newly created district, my lord, DLC has been.
You point out from the circular that it is possible to be transferred. You point out, don't make prayers for which you have no basis to support. Make a prayer, correlate with the provisions of the circular, office memorandum, judgments. Don't make submissions as if this is a judicial court. This is a court.
Yes.
We are not disposing your personal applications here. No, we will not. We'll dismiss it. Had done a counsel for the parties. This petition is filed by the petitioner so and so whose father expired, died in harness. On 28/06/2016, while he was working as a chowkidar, night chowkidar in village Darwa Kawahagi, under the Assistant Executive Engineer AEE Hatsinghi Mari Mechanical Subdivision Irrigation, presently in the district of South Salmara, Pankachar. Stop. The learned counsel for the petitioner submits that the petitioner submitted her application for being appointed as on compassionate ground. When did you submit? When did you submit?
My lord, 11/5/2023. 5/11/2023.
The presentation, it's talking about the representation.
Yes, my lord. I'm talking about the representation.
5/11.
Page number 39.
Earlier, your brother submitted.
Earlier, that was withdrawn, my lord. And thereafter,
When did your father expire?
my lord, 28/6/2016.
And you submitted on?
27, submitted on my lord 27/2/2017.
No, 7/3/2017.
Subsequently, it was 7/3, my lord, because before that, cell number 5.
Annexure 5.
Yes, my
Para
lord.
6.
There are six.
The petitioner submitted her application for compassionate appointment on 27/2/2017
Yes, my lord.
and also on 7/3/2017 before the respondent number 5. So the DLC, finally their meeting held on. Where is the meeting? Minus.
Page number 32, my lord, 31, 21/8/2017. Page number 31.
A meeting held on 21/08/2017 rejected the case of the petitioner on the ground of lack of vacancy. On the lack of vacancy,
Yes, my lord.
lack of vacancy.
And this page,
That page,
my lord, 32, my lord, last two line, 32.
stop. The proposal of the petitioner was kept pending for the next DLC. Then, next
My
DLC,
lord, 23/02/2018, page 33, my lord, next DLC. Yes, 33.
thereafter on 23/2/2018 also, the case of the petitioner was considered. However, the DLC could not take any decision against the proposal due to non-submission of the vacancy position. The matter was decided to be kept pending for the next
Yes.
DLC for want of clear vacancy position. So thereafter on 4/2/2022, the DLC again considered the case of the petitioner. The 4/2/2022 and 3/6/2022.
Yes, ma'am. Yes, ma'am.
The case of the petitioner was kept pending, but was considered, but would not be finalized because of want of vacancies. Stop it. Learned counsel for the petitioner submits that he has preferred a representation for transfer of his case, transfer of the case of the petitioner to be considered by the DLC for the district of South Salmara, as South Salmara subsequently has been carved out of Hubli as a new district. And there is presently district. There is presently a DLC. Stop. It is submitted that instead of keeping the applications pending, the same we transferred to DLC South Salmara for consideration. So, yes, government, what do you say?
So as a document already on the lordship, there is no provision of transfer here. Plus, he has been already considered, he is already considered for 4 occasions.
And learned counsel for the petitioner, for the department submits that the OM dated 1/6/2015 makes no provision for transfer. Stop. And therefore, the prayer of the petitioner ought not to be allowed. But having heard the counsels from the parties, it is seen that the case of the petitioner has been kept pending by the DLC for want of clear vacancy or the vacancy position. Stop. As per clause 10 of the OM dated 1/6/2015, it is specified that if any application of eligible candidates remain pending and cannot be considered for want of vacancies for a period of 2 years from the date of making such applications, such applications will require no further consideration and must be understood to have spent its force. Stop. The petitioner's father expired in the year 2016, 28/06/2016. Petitioner submitted her representation on 27/2/2017. Stop. Thereafter, the DNC had considered the minutes, considered the applications on 21/8/2017, 23/2018, 4/2022, 3/6/2022. Stop. In all these meetings, the case of the petitioner was considered, and for want of vacancy position or clear vacancies, the case of the petitioner could not be considered and has been kept pending. Stop. However, in view of the principle of principle 10 specified under clause 1/6 under OM dated 1/6/2015, once if when the period of 2 years from the date of making such application expired and the applications could not be considered for want of vacancies, no further consideration will be required and these applications be understood to have spent its force. So, in that view of the matter, we find no force in the arguments of the petitioner to transfer the same to a different district for reconsideration. The same being not specified under the OM dated so the petition has no merit and the same therefore makes dismissal. The petition accordingly stands dismissed. No order is to cost.
Item number 8.
Respondent so and so, they paid for 1 by 6. 3 and 6. Yes.
This be the lawsuit. Petitioner applied for grade 4 post minor. 3 numbers of grade 4 post minor. Case 32 minor. Declaration NEC minor. Case 32 and extra 10 minor.
Yes.
Case 32 minor. Here minor. There are 4 numbers of post minor. One is record keeper. Second one is PO to PO. PO to register and night officer. Petitioner applied for PO to PO. PO to register and night officer minor. by means of 3 separate applications, my lord. The selection for what they did, my lord. Call for interview petition on 14/7/2023. By means of 1 interview, my lord, they allotted other marks to other posts, my lord. Kindly see paragraph 10, my lord, 10 and 11 of the petition, my lord. May I read what's it? Paragraph 10, my lord. The petitioner basis that the petitioner appeared in interview on 14/7/23. The petitioner applied for the post of P1 to PO, P1 to registered and night officer, and no separate interview was held for above this post, my lord. No separate interview, my lord.
They are all grade 4,
Yes, my lord.
all three.
All 3, my lord.
Same selection board.
Only on, yes, on selection board, only five was in my lord. No written examination required because grade 4 post, my lord. The contention is that, my lord, how they,
It was held on the same day.
same date, my lord. 1 interview only, my lord. And different marks they put, my lord. And the other candidate, my lord, so far as the respondent number 6 is concerned, my lord. And respondent number 8 is also concerned, my lord. They applied for more than 1 post. Same procedure followed, my lord. 1 interview, my lord. So how they can put, my lord, for different posts, my lord? That is only condition, my lord.
So your grievance is that the selection made by the same selection board for 3 different posts on a singular date,
Yes,
not
yes,
permissible.
yes, my lord.
Not permissible under what provision?
That, my lord, I don't know under what provision, my lord.
Then why do you say it is not permissible?
So it's a normal practice, my lord. There are 3 numbers of posts, my lord.
All grade 4,
Yes, all grade 4, my lord.
same candidates may have applied for the same different posts. You have applied for 3 posts.
Yes, 3 posts, my lord.
So instead of putting you to an interview on 3 different dates, they have decided that you are there applying for 3 posts. Your suitability will be judged on the same day.
Marks are defined, my lord. How that they, my lord, allotted marks, my lord. Can you see, my lord?
How much did you get?
My lord, 13 marks to the petitioner for the P1 to PO, my lord. And 13 marks for the post of P1 to register. And 12.33 marks for the post of night officer.
So for the first 2 posts, you got the same marks.
That's it.
As second post, they perhaps thought you'll not be good as a night chowkidar, so gave you little less marks.
No, what is the basis, my lord? Another thing, my lord, I would like to bring your notice, attention, my lord. So I had experience, my lord. I worked for several years, my lord. Say my establishment, my lord. Paragraph 2, my lord.
No, the submissions are all right, but what is the basis of your submission? You have to formulate that.
My basis, my
You
lord.
can't say that this is wrong because you feel it is wrong. Is it, you must show that it is in conflict with some rules, regulations, judgments of the board, law laid down by the board. What is the basis?
Advertisement, my lord, itself speaks that, my lord.
Where is
There are
that?
3 advertisement 3 numbers of posts, my lord.
Yes. The qualifications, minimum qualifications are same,
Minimum qualification.
the pay is same, grade pay is same. They all belong to the grade 4 category. Where in the advertisement is the procedure mentioned?
Procedure selection of both, my lord, only there will be a fibers of 25 marks.
That's all.
Clause B, my lord. So my only contention is, but can you see the marks, my lord, how they have differentiated, my lord. So far as the respondents are concerned, my lord, they have obtained, my lord, more marks than.
No, that's a different issue. They have obtained more marks is a different issue.
Yes, my lord.
Your only ground is that between 1 and 2 and the third, there is some difference in the marks between 2 and 3. 1, 2 together and 3. Because the interview was held on the same day. And who was selected?
Selected, my lord, 6, 7, 8, my lord, respondent number.
6, 7, 8. So you are challenging their ground on. They fared better in your interview. They scored more marks. They scored more marks. Therefore, they are selected. What else are you addressing before this court?
This is only my submission, my lord. There are 3 numbers of posts, my lord. How they can assign marks in 3 different posts.
You show us that it cannot be done. You show us that there is a procedure laid down by which it cannot be done. The fact that the respondent scored more marks, you have a right to be aggrieved. You have come before the court. You may say that you are better. You selected this, that I can understand. But so far as you have applied for 3 posts, for 2 posts you got the same mark. So you can't be agreed with that. Only difference is in the 3rd post. It does not feel all right. I can appreciate that. That for all the interviews you have one selection board, same day. There may not be transparency.
Yes.
But on what basis are you saying that mainly because you feel it is not right? It is violating of some principle. You think and come back. Heard learned counsel for the parties. This next week, Mr. Sharma will address the court on the by referring to certain judgments which he'd like to rely in support of his contentions. Mr. C. Hazarika appears for the respondent. You come, there are judgments.
Item number 9.
Maybe. The petitioner is and maybe in 2008.
Regularization for how many years? 12 years.
Why not since 2011, maybe, he has been working without any regulation. And when it is submitted, several representation to the referee. Your working with the page number 12.
Yes, the government of okay. Get your instructions. Why you are making him work without regularizing property? Let him obtain instructions. Annexure 5. Yes.
Page 25.
Yes.
Communication made with the joint director of health services. To the director of health services. Providing the application, next page, is the representation of the petitioner. For confidence.
No, quite right. But what is your ground for? Is there a post? Is there a sanction post available?
I don't think basic ground is there.
So we get a problem then.
Donated the proper land where the hospital is.
Is there an agreement that you get a job?
Public commitment was given by the official respondent. In such cases, more detailed commitment is given.
Then on what basis do we issue a direction?
So these limited there to the because of the
Page 25 and 26.
that may be directed by the
25 is not your representation.
forwarding.
Already.
Forwarding them.
I heard learned counsel for the parties. This petition is filed by the petitioner, who is presently working as grade 4/sweeper/cleaner job. So the petitioner claims to have donated a plot of land. Any documents to show?
Yes, we are at page number 17. You can extract copy of the.
Donated a plot of land for setting up a health center. Stop. Learned counsel for the petitioner refers to the extract of the
You can extract the record of this register office.
extract of receipt from the office of the sub-registrar where or Jatrapur, where is that? Kashar, district of Kashar. to show that the petitioner is reflected as the donor and the Joint Director Health Services Assam is shown as the recipient stop. And the fee payable has been exempted. Stop. The learned counsel for the petitioner submits that he is a very poor person, and at the request made by the local authorities, he donated his land for setting up the health center, and he was assured that he will be given a job, grateful job in the said health center. Stop. Stop. The learned counsel for the petitioner has also referred to an application representation submitted by the medical and health officer number 1, Bonirgram, SD, Kachar district, addressed to the Joint Directorate of Health Service, Kachar, wherein it is stated that the petitioner has donated his proper land for setting up of the health center within his locality, and as he is in a very poor financial condition, he requested for being engaged in any capacity as per his educational qualification by the health department. So the medical and health officer 1 recommended that the offer made by the donor be accepted in order to improve the health services in that locality, and the donor may be considered for the post of a grade 4 sweeper within regular or contractual, whichever is applicable on a priority basis. Stop. Thereafter, the land was donated and this health center was constructed, and the petitioner was allowed to work as a cleaner or a sweeper. So petitioner has put in about 11 years of service. 11 years.
12 years.
12 years of service. However, in spite of his representation being filed before the competent authorities, his plea for being regularized in the same post has not been considered as on date. Stop. He had represented before the local MLA, the health minister of the state, as well as to the Director of Health Services, Hyderabad. Stop. It is submitted that his applications, more particularly the one submitted before the Director of Health Services, have been pending since the date of submission, namely 6/5/2022, and the same has not been disposed of. Counsel to the petitioner submits that he is before this court on a limited prayer that his representation be disposed of with a speaking order. So, Mr. D.P. Bora, learned counsel declaring the health department submits that he does not object to the prayer being stopped. Accordingly, upon hearing the counsels for the parties and upon clearance of the petition, this court disposes of his writ petition in direction to the health department, to the Director of Health Services, Hyderabad, Guwahati, to dispose of the application stated to be have been filed by the petitioner requesting for regularization. As stated to have been filed with the petitioner. So the Director Health Service will examine the case of the petitioner and pass appropriate orders as per provision of law. So any such order, speaking order that is passed by the Director of Health Services disposing of the representation, the same shall be communicated to the petitioner. So this direction is subject to the fact that the representation stated to be have been pending before the Health Department and stated to have been filed on 6/5/2022 has not already been disposed of. The Director will dispose of the representation within a period of 60 days from the date of receipt of a certified copy of the order. With the above observation, the petition stands disposed of. No order is proposed.
Item number 10.
Yes, it is. Here it is, the petitioner was appointed in the year 1993 measure, 1983 under compassionate quota measure. His post was also approved by the government as a rural handling manager. But subsequently, he is continuously serving measure, but he has not been given any benefit measure. So he is waiting for a regularization of his certificate.
Heard, let the council to the parties. This the petition is filed by the petitioner who was appointed as work charge roller handyman. His roller number 30614 by office order number 2288-93 dated 2009-1993. Of the petitioner since his date of engagement as a work charge roller handyman continue to work as such. Stop. Further, in spite of representations filed with the petitioner, his case for prayer for regularization has not yet been considered. Representations filed have not been disposed of.
Not disposed.
So we keep it pending or we dispose it of.
It was pending, my lord. He has submitted.
Do we want a disposal or it should be kept pending?
Lordship, at this stage, notice may be issued.
All right. It is submitted that the representations submitted has not been disposed of. The duty is before this court. Let notice be issued, returnable 4 weeks. Mr. Ardhor appears for all the respondents. Since the learned council appears for all the respondents, notices away. However, extra copies we furnished within 1 week from list after 4 weeks.
Item 11.
The petitioner had participated in a recruitment process for the Central Armed Police Force. Worship may like to have page 21 where the advertisement starts.
Medically unfit.
Medically unfit. Now, look, our ground is that the particular unfitness that they have found,
Tachycardia.
that requires a particular mode of review of the medical examination. This honorable court in an earlier judgment has held that that had to be followed. Once that is followed, perhaps the petitioner will not have a case. But if it is not followed,
Where is the earlier judgment?
my lordship.
Not enclosed.
I'm giving the book 2008 PGLT 331. 2008 3GLD 331. There, the
It was the same authority who had done the medical examination here and there, and the same disease.
See,
Same disease, the same defect. And I will show you that their present office memorandum requires the same.
print out निकाल ये दे दो अभी.
At page 334, it was put. Relevant question. It appears from the affidavits filed by the PSF authorities that the petitioners number 1, 2, 1, 3, and 4 and 6 have been found medically unfit for hypertension, and the petitioner number 5 having suffered from tachycardia. They are not appointed in spite of selection. It appears from the record produced by so and so the learned central government council that the candidates of the petitioners 1 till 6 were rejected having found medically unfit on the ground of hypertension only. Their blood pressures having been recorded as 150/90. Though the candidature of petition number 4 was rejected on the ground of being medically not fit or medically unfit, no reason has been cited as how he was found medically unfit, but his blood pressure is also recorded as so and so. The candidature of petition number 5 was rejected having found medically unfit on the ground of tachycardia. The pulse rate having been found to be 116 per minute. The petitioners being the villagers, it is not unnatural that they would present themselves for the medical officer, the PSF authorities check their physical fitness, their blood pressures may sometimes be recorded on the higher side, whose candidature was rejected only on the ground as narrated above. That being the position, I am of the view that since the petitioners are selected by the PSF authority for appointment as constable and the candidature of the petitioner was rejected on the ground to be found not tenable for the reasons recorded above, and candidatures of other petitioners rejected on the ground of hypertension or tachycardia, in my considered opinion, ends of justice will be met if the petitioners are medically examined again by the authority of the PSF within a period of 3 months. My clerkship will kindly have the office memorandum. Therefore, I was pointing out to page 28 for a moment of the petition, page 28.
The judgment doesn't say that you require a cardiologist.
I'll show from the standing order.
Page
Page 28.
28.
Lordship will find to Lordship's right side, clause number 11.6.2 down below. To Lordship's right.
28. Yes, medical
These
examination.
shortlisted candidates, Lordship will find,
Yes.
will be medically examined by the medical board constituted by the CAPF to assess their physical and medical fitness. The medical examination of the candidates will be conducted in. The medical examination of the candidates will be conducted in terms of uniform guidelines for recruitment medical examination for GO and NGO in CAPF and AR, issued by MHA UO number dated 2550 and MHA OM number so and so part 5116 dated 31/5/2021. Now, Lordship will have the 2021 notification, which I have annexed at page 47, page 46. I'm so sorry, page 45. This is 31st of May 2021. Lordship, thanks. Now, this uniform guideline, Lordship will find at page 47. Clause 6. Review medical board shall examine the candidate specifically for the deficiency for which the candidate has been declared unfit. Now, if we only go back to the medical unfitness certificate for once, my lord, Lordship will find at page 40. The initial ground on which she was rejected was cardiomegaly, which means an enlargement of the heart. So she was required to be tested for cardiomegaly. Review medical board did not find any cardiomegaly. Now, coming
No,
back
you
to
show us, therefore, these that medical officer will not do, but medical officer with the specified
yes, madam. Page
Specially.
48.
48,
Page 48, clause D.
clause D.
Review medical board may contain opinion or may obtain opinion of concerned specialist or super specialist of government medical college and
The
hospital.
page 48,
Page 48, clause D at the top.
yes, yes.
Review medical board may obtain opinion of concerned specialists and super specialists of the government medical college and hospital in case of doubt. Therefore, in cases of rejection in review medical examination, clinical findings should be corroborated with confirmatory tests, investigations, opinions of specialists and super specialists,
of government hospital, medical colleges, government approved private medical centers, whichever and wherever applicable. And Lordship will kindly come to 7E, the last clause. For candidates who have been rejected on the ground of hypertension or tachycardia, should be admitted, hospitalized by the board before giving their final opinion regarding the candidate's fitness or otherwise. Case of the petitioner is, I was sent to Narayana Hospital to check my cardiomegaly. They did an echocardiogram and they therefore wrote down, if Lordship will kindly have that echocardiogram, on what basis it has come. At page 42.
All right.
It is an unconfirmed diagnosis.
So
and I
now
rejected
what
this.
is the status you are rejected?
And I stand rejected. Now they are yet to go about to find out the merits of the candidates and to publish a final select list.
Hmm.
I don't have a review medical for their office memorandum.
Yes, Mr. Goswami,
I need one.
what do you say?
Let them treat according to guidelines. That is all.
You conduct the review medical as per the guidelines. We direct you to do it. All right, let him get the instructions for a. When can you get it? Give us a date, 16th. Heard counsel for the parties, this petition is filed by the petitioner, who is agreed by the rejection of our candidature by the by whom? By the
Bonus.
where is that?
But the medical board.
Where is that order?
Yes. Lordship will find it. Page 40, my lord. Review medical examination report. That is all.
Has been rejected on the ground that the review medical examination report reflected that she is suffering from some heart ailments and was accordingly declared to be unfit. Stop. The Honourable Counsel for the petitioner submits that this rejection of the petitioner and considering her to be unfit is contrary to the circulars notifications issued by the Ministry of Home Affairs. Stop. The petitioner had applied for selection to the post of a constable in BSF.
In the CAPF.
CAPF. Stop. Physical and all, you're clear.
My lord, physical I have clear, written I have clear.
It is submitted by the learned counsel to the petitioner that the candidate has already cleared her physical test as well as written test. But however, during the medical test, she was declared to be unfit. Learned counsel for the petitioner refers to the circular guidelines for review medical board, review medical examination in Central Armed Forces Police and Assam Rifles, which are circulated by the Government of India, Ministry of Home Affairs, by OM dated May 31st, 2021. Stop. In the guidelines for review medical board, it is specified that for candidates who are rejected on the ground of hypertension / tachycardia, they should be admitted or hospitalized by the board before giving their final opinion. Stop. That apart, their cases of rejection in review medical board should be corroborated with confirmatory tests / investigation / opinion of specialists / super specialists or government hospitals / medical colleges / government approved private medical centers, whichever and wherever applicable. So, the Learned Counsel for the petitioner submits that the petitioner, having been rejected by the review medical board on the ground of having the condition within which tachycardia, the competent authorities are duty bound in law to follow the mandates and the guidelines. Once the mandate guidelines laid down by the OM dated May 31, 2021. Being agreed that petitioners before this court praying for appropriate leave direction and for interfering with the orders rejecting her candidature. Stop. Mr. UK Goswami, learned CDC, appears for the respondent and pays for a short date to obtain the instructions in respect of the matter. As agreed to by learned councils, let the matter be listed again on 16th. 18 is a holiday. 21st. 21st. It's on 21st.
The interim will be considered the mistake.
It is submitted, the interim prayers will be, it is the interim prayers of the petitioner will be considered on the next returnable date. Stop since, although no notice has been issued, the learned counsel for the petitioner will fund his extra copies. The petitioner within the course of the day.
Supplementary list, item 48.
Yeah, in the morning I am for I have vacancy.
99. I hear where it is at least somebody.
What is your prayer?
The vacancy is not available member in the concerned department, member, any other department.
Where is the order of the
SLC,
is it SLC or DLC?
SLC, member.
SLC
Page number, relevant total 41,
31.
serial number 3.
Which says vacancy position 99/2001. Then from where will they consider now?
Against the specific vacancy, DLC consider my case further. And now that SLC
It is not there.
against the specific vacancy, my name will be considered. But and another aspect, my lord, SLC may consider any other department during the year, my lord, vacancy.
99.
99. If not, my lord, the SLC may reject my case.
What is the point making this orders? Think there is anything we can do?
There is a judgment I am relying, my lord, if the DLC recommended, my lord, SLC cannot take the current view, my lord.
Show us,
Regarding the vacancy position.
show us the. Where is the DLC report?
DLC minus page number 14. Serial number 5, man.
Recommended for grade 3.
Grade 2.
Is only 1%. Only perform 11% more.
Thereafter, my lord, SLC rejected 5 things, my lord, page number 20, my lord. Serial number 19, my lord.
Yes, then
More than zero. Thereafter, that minus has been set aside by this court, my lord. Page number 25, man.
then what are
Issue number 2, my lord. Then even for my lord, page number 28, paragraph number 8.
okay, then what?
Then my lord again, state level committee rejected
If we look at the consent. SLC may reject my case in any other department in the year 2019-91 minor vacancy is not available. Only that one, my paragraph number 7, I think this case. And
Comrade, we'll issue notice when you have to think about hard done and counsel to the parties. Issue notice written in 4 weeks. Since Mr. T appears on the respondents, notices of wait. Extra copies be furnished within 1 week from the date. Yes, after return.
Congress.
Item 49,
Are you appearing, madam? In the earlier matter? Earlier matter? Respondent 1. Yes.
Here, Malad, I have challenged the appointment for the private respondent as public proceeding of the ministry.
What is that judgment, Mr. Additional AG?
Madam, in this case, madam, there will be continuously, then a walk-in interview was conducted.
No, there is a judgment of the apex court with regard to.
Madam, then you also be talking about the original. The original case will not come here, here condition is different.
My
They
content.
have taken that walk-in interview, the respondent number 5 or 6 who was actually appointed, did not get the walk-in interview. I will find out, I will give you one week's time what has actually happened.
Apart from this, another ground is there.
Hmm.
Under 24, say, PC matter, something about both. The panel must be prepared by district magistrate in consultation judge. That has not been done because your lordship, I have managed the panel, the lordship kindly fill the panel,
Page number
page 22.
22.
Yes. It contains the only initial of district magistrate. It should have, my lord,
It may be there in some file.
And it's mentioned there itself, this very second line. You refer to the subject heading above, I am the owner who informed there. In process of the record or reference discussions were held in
No, you're referring to page number
page 24.
24.
Discussion was held, when it's none. Coming with the petitioner of meeting.
this is, my lord,
Consultation.
Annexure 1, your lordship, my lord. It is, my lord. Page 17.
Hmm.
With reference to the subjects, last paragraph. I am directed to request you to publish the panel of name of advocate indicating their age, their qualification, address, length of practice. In the ratio of 1:3 against each court of the entire district for appointment of advocate for appointment of such. With due consultation, the what due is there. Mere consultation that will, my lord, interpret in, that may be interpret in one.
You have to distinguish between consultation and due consultation.
Yes, madam, because due consultation, everything is done by the district magistrate, he produced that.
That will be really the evidence from the records.
Yes.
The
And
records will-
another thing, you must kindly see page 18, my lord, page 19. Date has been given. Date has been given, every interested candidate supposed to be appeared on that day. That is the 2nd February, and your lordship will have page 20. His signature is not there, they maintain a attendance, in the attendance, his signature is not there.
Who's private responsibility?
Private respondent, he did not appear. Then what is the meaning of all this following all this? If somebody will be there,
Where is your signature?
yes, my signature, your lordship will find 3.
Okay. Mr. Additional, please get your instructions. Hard level counsel to the parties. This petition has been filed by the petitioner challenging the
Page 25.
notification dated 1/6/2023, whereby the private respondent was appointed as assistant public prosecutor.
Yes, public prosecutor.
Public prosecutor.
Page 25, my lord. Second line, second paragraph. Notification number E25.
Public prosecutor of Hubli. District of Hubli. So, learned counsel for the petitioner submits that besides the fact that the list forwarded by the district magistrate was without any consultation of the district and session judge or session judge Hubli, as required under the provisions of law. One, the interview which was conducted by the authorities was not attended by the private respondent. As such, the notification dated so and so, which was issued, appointing the private respondent, was done without the private responding even appearing for the interview. So, under such circumstances, the petitioner is before this court challenging the appointment of the private respondent. Mr. T. Mazumdar, learned additional AG, appearing to the state of Assam, raised for submits that you'd like to obtain the instruction by and instructions from the department with regard to the allegations made.
Both the issues.
Both the issues. We not issue notice at this stage, you get your instructions. At this stage, the court permits the learned additional AG to obtain the required instructions. Thereupon, necessary orders will be passed on the next returnable date. On the next date, please. List again on 25th. Only 25th. Extra copies be furnished to the learned additional AG to obtain instructions.
For orders, they visiting items 12 to 14.
Yes.
I am for the respiration. I wanted to trying to file an application for vacating an interim order. My mother I also submit that my taking of this the high for vacating the interim will in fact not determine the main issue raised in the respiration.
No, I agree. My lord, what I submit, that by the interim order, the posts of the pollution control board of my, it's called environmental scientists, are directed not to be filled up. That is neither serving the purpose for the board, nor it is the public interest. And my lord, there is no natural dispute. So far as this main matter is concerned, it will be only on the question of interpretation of the state under which they were appointed and they were. No, I also agree because I had my next step of promotion is postings. So my lord, diggings are ready. Diggings are complete. If my learned friend wants to argue it, my lord, matter is not that no. Argue it today, I will welcome it. Or if he has got certain details. Your worship, your worship. But there is the matter finally.
You lay it on
This
Thursday.
matter should not be allowed to wait.
Thursday. 17th.
Admission hearing, nothing now.
Admission hearing. Or we can have it on 16th. if you want. 16th. For admission hearing.
Yes, sir. I'm a disciplinary.
You are appearing?
There is other connecting issue. But as far as item number 13 is concerned, lordship. Therefore, the response number 8 lordship is already declared lordship. No, sir. Other question.
One of them retired.
My
13 you are appearing for?
response number 8 lordship.
8. Who's for the petitioner? You are for the petitioner.
Yes, sir. I think, sir, it's not fact.
We'll take up everything on 16th. 16th.
All right.
On admission, item 15.
The interim order is actually the next thing.
Interim order passed earlier will continue till the next date fixed. Yes.
May I please, your lordship, my senior is in length, may kindly pass over the matter for the time being.
Timing is not possible today. We'll have it. No, timing is not possible today. We'll have it on next week or some other day. You can have your convenient dates. He was supposed to furnish instructions.
Is it?
Yes, Mr. Solomon.
Technically possible for the timing, as this method was to be recommended by senior advocates within IS.
Then we shift it next week. Monday. Wednesday.
21st.
21st. 21st, all right, 21st. Have it on 21st. As it is submitted by Mr. M. Sharma, Learned Counsel, to the respondent bank, that matter will be addressed, that the arguing counsel has been engaged to address the court. Matter stands adjourned till 21st.
Maybe 22nd or
22nd is not possible. 23rd. 23rd. Mr. S. Chakraborty appears to be petition. On 23rd. List on 23rd.
Item 16.
Yes, Mr. Patani.
Petition number 25, another petition number. It required to be taken along with this application number 3925 of 2023.
It is submitted by Learned Counsel, Mr. Patgiri, that petitioner number 2 has filed another writ petition being WPC number 3925 of 2023. It is submitted that both the writ petitions be taken together and listed accordingly. Mr. C.S. Azarikan appears for the respondents. Accordingly, let this matter be listed along with WPC 3925 of 2023 on 25th August.
Item 17.
Yes.
We wanted to see the cabinet decision from finance department.
Cabinet decision. Mr. Nair, do you have the cabinet decision? Page 100. No, is there any proposal pending?
in this regard, not the administrative department and the subsequent after that. They have already filed a application for that, getting it in that call.
No. The last order, you have to get instructions as to whether in terms of the cabinet decision, any proposal is pending. Before the finance department. Which is the administrative department? Any proposal sent? Page number
Then paragraph number paragraph number 5.
Affidavit filed by?
Richard Ahmed Lawson, he is the joint secretary. Urban Development Department.
Yes, then paragraph number
Paragraph
5.
The deponent states that so far provincialization of the service of municipal administrative representation is concerned, the finance department will not accept the proposal. Since the state government gives devolution grant to the local body 10% of the 10% of the recommendation of the state finance commission, and as the 73rd and 74th amendment of the Constitution of India has accorded separate status of government with specific powers and functions to local government. Provincialization of services of the local public are concerned with the spirit of the Constitution. Now, going back, he said in the big law that also proposal was used also that the Sunday did that.
That is the Departmental. Here, the within dictionary is based on the item 2. Criminal dictionary based on the item 2.
Yes.
Criminal dictionary not because is on the I have reading page 2, item 2. The proposed substance and to provincialize in principle 5170 posts of 5 categories of ULB, including regular scale of pay of sweepers along with the corresponding scale of pay recommended by the court finance commission. Then item 4. Salary provision for the provincial ULB employees, including BMC, will be made out of their devolution grants under the relevant heads of accounts of the budget provision of the concerned department and not under the grants in aid of its account 3604 compensation and assigning to the local government. Item 5. The employees of the ULB will be given the revised pay scale as per ROP 2010 with prospective effect on the basis modification. The item 6. The PRI and ULB in 6 area will given as this is not related to us, these are the 6 groups. So compensatory grants of ULB to be there as the that is not required. So our item 2, item 4 and 5, it's the for. So this is the
Mr. Nayak, you come back to your affidavit, filed at para 5. This is a cabinet decision. At page 100, it is a cabinet decision.
Expectations of committee of growth on the final report of the supplementary report of some state finance commission on stopping pattern of local bodies for progress. Not has been approved also. Approved them. The stopping pattern of PRIs will be examined by the committee to be constituted.
No. What we are asking you is these are the proposals placed before the cabinet.
That is why I'm saying what has been approved by the cabinet.
What has been approved? Yes, we are there with. No. Number 2.
Number 2, the proposed substance and be provincialized in principle. 5170 posts of 5 categories of PLP, including regular scale of pay of super along with consequence.
What is PRI?
By the court. Panchayati Raj.
Panchayati Raj institution. So the so they are referring to number 2 and number 4.
Two lordship, the proposed substance stand and to provincialize in principle. 5170 for 5 categories of ULPs, including regular scale of pay of super along with corresponding scale of pay. So that decision was taken that 5170 posts for 5 categories.
This was approved.
The proposed
unless the cabinet has subsequently withdrawn this decision, this is a policy decision. How can the commissioner make a statement that this is not in consonance with the constitution?
Allow me some time.
We have granted you twice. We have granted you twice.
It got to be checked on last day, on one of my colleague was appearing. Today he is unable to come to court. That is why I am getting. So what I am submitting notice, the executive time meeting is of the housing and urban affairs department. They have said that the finance department has rejected the proposal. So far as we are informing, also finance department have asked for some time to manage it. So I'm not grounded sometime in the meantime.
But this affidavit filed by the House Urban Development, para 5, runs contrary to the cabinet decision. How can the secretary say that this is in conflict and runs counter to the spirit of constitution? The cabinet has taken a decision. Is he aware of the consequences of making a statement like this? Mr. Roman? No instructions are forthcoming, you want some time.
That is true, but will not be given decision when he is contradictory to the cabinet decision.
Heard Mr.
Decision is a court of law.
H. Raman, Senior Counsel assisted by Mr. Suel, so I came to the petitioner, Mr. B. Nayak. Appearing for the finance department, renews his prayer for accommodation to obtain necessary instructions in respect of the steps, if any, taken by the finance department in respect of the decision taken by the cabinet of the state as is reflected in the extract of the cabinet decision stated to have been extract of the minutes of the cabinet meeting held on 4th of September 2013. Available in Annexure B, page 100. This is Annexure B of what? B of what?
Annexure B is 100.
Writ petition. Of the writ petition. Stop. Mr. Nayak submits that you will obtain the necessary instructions and address the court on the next date fixed. Matter stands adjourned, enabling Mr. Nayak to obtain the required instruction. Matter stands adjourned for 2 weeks.
Another communication is also there under.
No, some more time, you just obtain the instructions whether it is done or not.
This application already entered.
Huh?
This employees have already entered.
You are to find out whether any proposal in respect of this is there or not. Has it come? It is possible it may not have come.
So far as this certificate is concerned, proposal was rejected as finance. That much is clear. Why it was rejected, rather than this candidate. That instruction.
You get it within 2 weeks. Let the matter be listed again on 11 September. Anyone else appearing for the respondents? You should stand up before the court completes passing orders. Otherwise, if you want your names to be recorded, you should mention it. You are appearing for? The mic up for an ID. Respondent number 2. MS Bora appears for respondent number 2. Urban Development. Mr. Dhor appears for Urban Development and Metropolitan Authority. Anyone for Jorat Municipal Boards? All right, list after 2 weeks. At least on 11th September. Yes.
Item 18.
Yes.
Because the petitioner is praying for settlement order by which the intervening period of his cell service to his reinstatement in service has been held to be rational and on the principle of no pay, no.
He's been exonerated.
But what had happened is prior to his joining service, while he was appearing the last year examination, he had to undergo a trial on Rajasthan civil services, civil examinations. Rajasthan Public Examination Act was for cheating during the last year examinations, and he was then let off on the provisional of offenders. Now, that he had not disclosed when he applied for the job. When the job was being, when it was verified, they found that he had a criminal antecedent and they dismissed it. What is his services were terminated. He approached the Honorable High Court of Judicial Rajasthan, got a favorable order, asking his directing his reinstatement in service. They went up in a writ appeal, and in the writ appeal, my lord, during the pendency of the writ appeal, he was ultimately reinstated. The writ appeal was allowed, respondents went up in a PSL. Well, the High Court, the Honorable Supreme Court directed that the respondents have to relook into the issue and see whether the offense or the punishment was enough to have denied him service. While allowing him to continue in service for the orders passed in the pendency of the writ appeal, the later on benefits were not given because she could find at page 34. And so page 35, madam. Para 7 of the order. Page 35, para 7.
Of
Of the repetition. Para 7.
Yes. Yes.
Since number so and so Naresh Kumar Yadav has already been reinstated into service conditionally with effect from 20 to 30 subject to final outcome of the DP civil special appeal number so and so signed by user of India CRPF before the division bench, which was later dismissed by the division bench of the Honorable Court by order dated 4/7/14. The SLP has also been disposed of by the Honorable Apex Court. As per the order of the Honorable Apex Court, the individual is to submit his representation for consideration of his case afresh. Accordingly, Constable Naresh Kumar Yadav of which has submitted his representation dated 26/4/17, they request that he be continuing service.
He was not really absolved. He was not technically exonerated.
Well, there was no crime on him.
No, maybe, but ultimately the writ petition was dismissed,
No, repression was allowed. Allowed.
confirmed.
Madam?
Then it was confirmed in the appeal.
Taking.
Then it went to Supreme Court,
Supreme Court. Supreme Court said that
take him back in service.
no, the Supreme Court said that if he is continuing in service, he make a press representation because the hiding of the fact which was hidden, whether that particular crime would have been big enough to deny him an appointment or not was to be evaluated by the respondents. So make a representation and all cases will be decided accordingly. The petitioner's guilt was that he was convicted of committing an offense of cheating in the class 10 examination. And he was later on the
What was the order passed by the authority of the representation?
this is the order that I'm reading. I'm reading the very order.
Starting from page 32.
32 minutes. Should I read the whole one?
No.
Now, then it says, keeping in view the above at page 35 para 8, The direction issued by Law Directorate and the court order dated 22/11/16 passed by the Honorable Supreme Court has been considered. The following orders of the matter hereby issued. Services of Naresh Kumar Yadav of this unit will be continued. As per FR 54, the period of date of termination of date of reinstatement, that is from 2005 to 13, is treated as period not spent on duty, and he will not be entitled for any pay or allowances for the period of expense of no work from
He was appointed on which date?
Initially, my lord, he was initially appointed on 29/10/2004.
Then
He was terminated on 7/10/2005.
7/10/2005.
2005.
Then he was reinstated.
Petition was allowed on 25/2011.
2005.
20th of May 2011.
Mhm.
Thereafter, he was reinstated on 2012. 2013.
So he is back in service from 13.
13.
So now he wants from 2005 to 13,
13.
2004 to 13.
The issue is not of the salary part. The issue is whether it can be probably obliterated from his career, not to give him any benefit as period not spent. Whether he would be entitled to retain his seniority and continuity in service, because this order takes away those areas of my life. People have marched ahead of me. When I'm required to be, I deserve to be retained in service.
Yes, what do you say, Mr.
Take the party with the notional benefit, why take it? And FR 54, the reference, my lord, this honorable court has said under FR 54, this could not be done without giving me notice. There was no notice. Neither we are not going to give you that, we are going to treat that period as we are not spent on duty and you will not be entitled to pay and service. That notice was never given. They have referred to FR 54.
Because it is pursuant to direction of the apex court.
Yes, the apex court said that I will make a.
There is no question of notice because you have already filed a representation pursuant to the
But
direction.
that is for my retention in service. FR 54 when they refer to, it is their reference, I did not make a reference. FR 54 when they make a reference to it, FR 54 says that if you do not give, if you treat the period as period not spent on duty and if you do not give him salary for the period, a prior notice is to. That is
Okay,
not.
then we'll hear the matter. Required some hearing. Readings are complete.
Yes.
We admit it. For hearing, admit submitted by the council, that readings are complete. Matter be listed for hearing. In part 2. You listed in part 2, make a mention, we'll take it up.
Perhaps if the word ensuing part 2, otherwise it goes to which part 2.
The next part 2 list to be prepared. So,
Item 19.
Yes, Lordship, it's like the evening reply, Lordship, I have not received the check mine more. Plan has been received, I need to check there for some more time. There are 5 Lordship.
Supply one.
Mr. S. S. Roy, learned CGC submits that the copy of the affidavit in reply filed by the petitioner
On 25/2/2022.
is not available with you. He prays for a short date to complete to obtain a fresh copy. Mr. Soronian and counsel appearing for the petitioner undertakes to partition an extra copy of the affidavit in opposition. Sorry, reply. Affidavit in reply. Reply. Placed after 2 weeks, 3 weeks,
Mine.
3 weeks.
100.
Item number 20.
And returning the department after the demise of our brother, the course of the sweeper became vacant against that the vacancy of the petitioner was And again, that we can see the petitioner was temporarily engaged on honorary basis. Until now, she is serving, being more than 7 years, she joined in the year 2016. She is serving with a very easy income of 1,000 per month.
He did not take part in selection, or you did not permit her to take part in selection?
So didn't take took part in selection process also, and her upper ability is also not. They have, they have an experience of their age certificate. He was born in 76, my God. There is even upper ability is not. There is no annexure regarding any selection procedure. They have only stated about it. And they have not annexed any documents which shows that there was actually any selection process.
Yes, you have to say that there was a selection held. She did not apply. Where is that? Where statement is there? What selection, which date, which advertisements? Your statement at para 8
Yes.
is not even a statement to your knowledge. So it will have to be taken to be a statement on record, based on record. So where is the record to suggest that there was some selection process held? What selection for which year? Which advertisement? Merely saying that she did not take part. She will take part only if you initiate a selection plan. Learned Standing Council MS7 photo B 6 liberty to verify a statement of the department made in the affidavit in opposition at para 8 to the effect that in the selection processes undertaken by the department, petitioner did not participate. So, Learned Counsel for the petitioner submits that this statement is not supported by any document to suggest that selection process was indeed undertaken by the department for the post of a sweeper, and the petitioner deliberately did not participate in the selection process. So, that view of the matter stands adjourned for 2 weeks, enabling her to obtain the relevant instructions. Some of the state of statements in para 8. 11 September.
21.
Yes, Mr. Mannan.
Make please your lordship. This matter, one thing. One thing I like to point out, although the administrative, the respondent and administrative department has already highlighted in whatever submission will make nice, that will be submission of the administrative department. So I have no separate submission on that.
Who is the administrative submission?
Water. So whatever you in
You want to rely?
it's absolutely.
Yes, so
So this matter is basically covered by the division bench judgment of the Supreme Court. So before going into the judgment, I'll just go over the gist of the case. I'll come to the affidavit which my learned friend has filed, that I will come later on. First, the matter, your lordship, the gist of the matter. The petitioners were actually master workers, your lordship, in the Nagaon Water Resource Department, and were appointed on various dates prior to 1993. So I will take your lordship, I will not go into all these in between facts, that's not required. Main problem started, your lordship will say at page annexure 3, page 23.
yes.
Here, your lordship, will kindly see this order. This order, I think your lordship knows, but still I'm showing this order because the following are hereby notified to compliance by all state government departments as applicable to the master workers, casual and similarly placed employees were appointed prior to FRBM period, it is 1st September 2005. There is no dispute. All these petitioners are prior to. The minimum pay scale, this is very important. That is what I am trying to do. Minimum pay scale, so and so, DNS allowance, so and so will be admissible. Two, workers categories of workers who are already drawing higher pay band will continue to be existing structure. We are not concerned with workers. We are only concerned with master workers. This is adherence to the Honorable Court's order dated 8 June 2017 in Read Appeal number 45/2014 State of Assam versus Upendas. So this is basically was done on the basis of the division bench judgment of the Honorable Court. So now your lordship, second part I will read. This will come into force from 1/12/2018 for release of benefits up to 31/3/2019 from the current financial year so and so. And for area from 2017 1/8/2017 to 30/11/2018, our cabinet approval in the financial year so and so. The benefits as entitled in A above shall be admissible on specific recommendation of the committee notified so and so, and formal approval of the Honorable Minister Finance. So this is basically on the basis of which the pay scale was made. Now page 27. Now this is the order of the finance. The Commissioner Secretary of all the departments, water resources inclusive. This is I will read the subject. Payment of minimum pay scale to master workers, schedule and similarly placed who were appointed prior to FRBM period workers in pursuance to on the court's order dated so and so. Date appeal number so and so, state versus different class. So this was also passed by the Commissioner and Secretary. I'm not reading again the same thing. So your lordship, what has happened thereafter? All these petitioners were given the benefits. All these petitioners were given the benefits that your lordship will see from the annexure at page 5, page 32. Now this has been issued by the Water Resources Department to the Chief Engineer for payment of the minimum pay scale to all the master workers. I'm not reading again this. It's no use going through the same thing one and again. So your lordship, thereafter, from annexure 6 onwards, these petitioners, sorry, annexure 7 onwards, so page 36, each and every petitioner's hearing, all these petitioners were given the pay scale. That is annexure 7, page 36. One, if your lordship reads one, that will cover all.
Yes.
Now this is for the person concerned. These 12 petitioners were, I think you about more than 18 petitioners. 18 petitioners, they were paid the scale. Brought to the pay of master role and fixed pay employees are hereby enhanced of their pay in the scale of pay, so and so, and grade pay, so and so, and medical allowance, so and other allowances that are admissible with effect from 1/8/2017 as per Finance Department order number so and Deputy Secretary Government of Assam Water Resources Department dispute number so and Chief Engineer Water Resources Department Chanmari so as per list and close here for ready reference, which is approved by the Finance Department Dr. Assam page so. These persons, your lordship, from page 36 onwards, the 18 persons were given the minimum pay scale. Minimum pay scale. Then your lordship will kindly turn to the impugn order. That your lordship will find at page 51. This is a notification which is under challenge. Annexure 9, page 51. Lordship will kindly turn to that. This is of 3rd October 2019. In suppression of Finance EC Department's earlier notification number 12. The following are hereby notified for compliance of all state departments as applicable for master role, workers, casual, and similarly placed employees were engaged prior to FRBM period. That is so and so. the fixed wages remuneration of rupees 15,900 with DA will be admissible, which will undergo revision whenever pay scale changes based on enhancement of DA and recommendation of pay commission along with medical allowance of rupees 600 per month. Work stars categories, I'm not reading. And the last four, serial number 4, I'll read. 3, the employees will draw their wages under the head of account salary as other regular employees of the government of administrative convenience. However, they will not be considered as regular employees and no such claim can be made on this basis. 4. Further, the eligible MRWC casual employees will be covered under the Pradhan Mantri Suraksha Bima Yojana, so and so and so and so. Area claim from 1/8/2017 to 30/11/2018 shall be considered after cabinet approval in the financial year 2019-20. So what has happened? Subsequent to this, the executive engineer has complied with the order and we were from pay scale, we have come to fixed. From the minimum salary pay scale, we were brought into fixed. Now, why we were brought in? That is the question and we are challenging that. For that, you are actually kindly take up the judgment of the division bench. That is,
Upendas.
that is already there. We have given a copy of that judgment. If you are also kindly take up the judgment for me. This judgment you will also kindly take up. Paragraph 22. I'm not reading the judgment. Paragraph 22 of the division bench judgment, which has been referred. I'll read the judgment. It is, however, heartening to learn that the state government has agreed not to terminate the master workers and similarly placed employees working since last more than 10 years, not in sanctioned posts, till their normal retirement, except on disciplinary ground or on ground of criminal offence. The state government has also agreed to enlist such employees in health and accident and death insurance scheme, which will be prepared in consultation with the state cabinet. We appreciate this positive stand and a stand of the state government taken as a welfare measure for the betterment and security of the employees in question. We accordingly direct, this is the part, the state government to implement the measures without further delay. Besides this, we, in the light of the decision of the Supreme Court in State of Punjab versus ZCC 2017 1 SSC 148, also direct the state government to pay minimum of pay scale to master roll workers, work charge workers, and similarly placed employees working since last more than 10 years, not in sanctioned posts, with effect from 1/8/2017. So this order was implemented by the order of the Finance Department, subsequently by the Commissioner of Water Resources. It has been implemented. We are given the minimum of the pay scale. Now suddenly by this notification, they have the notification that I have shown at page 51. These persons were in the pay scale, minimum pay scale, they were brought into fixed pay without specifying why. Now, and this honorable court has very clearly stated that they should be put in the minimum of pay scale. The court did not say you put them in a fixed pay. So this court order, though it was implemented earlier, they have again reversed it and brought them under a fixed pay, which is against this honorable court's division bench order. First point. So
What is the financial, what is the difference in terms of finance steps?
financial difference there may not be, I don't know, may not be so much difference here. Because the minimum of pay scale is a pay scale where you get so many things. Like the DA, HRA, everything comes. And secondly, your lordship, there is a revision of pay.
No, but here DA is admissible.
Whatever it is, but the question arises, what is wrong then keeping them in the pay scale? Now, the affidavit is very interesting. This is of a genius mind worked why they brought us to the pay, fixed pay. The affidavit filed on
By
by the respondent number 4.
Water resources or
No,
fine?
this is by the finance.
Fine.
Other persons did not say it. That is why my learned friend initially stated. Now, finance department affidavit, your lordship will find, this starts from page, I think, 76.
Yes.
Very interesting point has been taken. I'll read that point, para 8, page 79. That with regard, may I read you? That with regard to para 9 of the writ petition, the deponent begs to state that the Honorable High Court by order dated 8/6/2017 passed in connection with beat appeal number 2 directed the state government to pay minimum of pay scale to master, work charge, casual and similarly placed worker working in various departments of the government of Assam for 10 years, but not against sanctioned posts. In adherence to the Honorable Court's aforesaid order, Finance Department issued notification number so and so, whereby the minimum pay scale was notified as so and so, grade pay so and so, medical allowance so and so, DNS allowance so and so, as per state ROP 2017. Further, the Finance Department, after a closer reading of orders of Honorable High Court, observed that as per order of the Honorable Guwahati High Court dated so and so, these set of employees are not supposed to be extended the benefit of minimum pay scale, but fixed amount paid at minimum of pay scale. Now, this is the genius mind working. I'll come to the further. In view of the above, the notification dated so and so was modified, and notification dated so and so was issued, whereby fixed amount paid at a minimum of the pay scale with DNS allowance, medical allowance was notified to eligible so and so who were approved by Finance Department for granting the benefit of minimum of the pay scale. Now, one more para I will read you. Let us go to para 11, page 82. That with regard to para 12 of the writ petition, the deponent begs to state that the Honorable High Court by its order dated so and so passed in connection with writ appeal so and so directed the state government to pay minimum of the pay scale and not regular minimum pay scale. Now, when rate to master role casual workers and similarly placed workers working in various departments of the government of Assam for the last 10 years and not in sanction post with effect from so and so. So for that, it is minimum of pay scale and not regular minimum pay scale. I don't know what they mean by that. Now, I will provide your lordship a copy of the judgment of the Honorable Supreme Court. The Honorable Supreme Court judgment from on the basis of which the judgment of Jagjit Singh, on the basis of which the order was passed by the division bench in writ appeal offenders. Here, court has specified.
No, essentially, Vendas was disposed of
Yeah.
on the submissions made by the state
Yes.
that we are providing
What is
fixed
what
and
we are providing?
benefits. There was no specific direction in terms of in Vendas. The direction of the court that you should pay,
Minimum of pay scale.
but
Now, what do you mean by minimum fixed pay? I'm
minimum of
asking
the pay
that,
scale.
what do you mean by minimum of pay scale? Is it fixed pay? Or whatever it is, para 61 euros, and para 61, page 224. We are not concerned what amount we are getting or not getting. You are interpreting what kind of interpretation you are making? Para 61, I'll read that, page 224. In view of the position expressed by us in the foregoing paragraph, we have no hesitation in holding that all the temporary employees concerned in the present bunch of cases would be entitled to draw wages at the minimum of pay scale. Now they have specified what is minimum of pay scale by the Honorable Supreme Court. At the lowest grade in the regular pay scale, extended to regular employees holding the same post. So this was the interpretation that is by the division bench. By
What is your interpretation?
the interpretation they have stated in their affidavit.
Your.
My interpretation is that they are to be put in the pay scale. Pay scale is so and so, so and so, so and so. Pay scale at the lowest grade in the regular pay scale. So that the regular employees are given. That means the pay scale which is the lowest in that grade should be given.
That's not fixed pay, not XYZ pay, whatever it is.
This is what is being given to you.
No.
Is it not?
Is it fixed pay? Fixed pay is a pay scale.
No. The direction is that you have to be given the minimum of pay scale,
Yes,
which is at the lowest grade.
yes. That
So
was
there'll
given
be-
to us.
There was a regular pay scale.
Yes, that was
So
given.
you'll be given a pay scale, which is at the
The minimum of the
Minimum.
regular pay scale.
minimum pay scale.
That was given to us.
Right.
Initially.
Now,
Then why
They have-
they have-
they have now decided to give you this in the form of a fixed pay.
Why? How? In what? They should have come before the court. How they can do it? Once the judgment has been and entered is final, they cannot change it.
Therefore, the question is, you will have to say that this deprives you
Yeah.
of what benefit?
Of all the benefits, because I will be getting the every month, every year, the pay scale is revised. When it is a big scale, it will not be revised.
I don't think that is the mandate of.
And there will be many other benefits. But my question will be,
See, the Upenda's judgment essentially rejected everything. The Upenda's judgment did not accept the contentions of the appellants. However, in view of the offer made by the state,
yes,
the court said that all right, you provide all that, and also the minimum of pay scale as in
as per the decision of Judge.
Jagjit Singh. Now, Jagjit Singh is a case where these people were working equal pay for equal work,
Whatever it is.
temporary, whether it is applicable, not applicable. But ordinarily, regular people in regular scale, people in regular employment and people working temporarily, there's a difference
There is
in
a
pay
difference,
scale.
but that has been.
So
specified here.
therefore the court said you gave the minimum of pay scale.
So give us the minimum.
So they have been
What
giving
is
you the
problem?
minimum.
So why you reverse it?
You are entitled to the minimum of pay scale.
Yes,
They have given you the minimum of pay scale.
why fix?
But if you say that no, minimum of pay scale means the pay scale has to be given to you that.
That has been given to the regular.
So minimum of that scale,
Yes, minimum.
that you have got it in the form of a pay scale,
That
plus
we
the
have
other
got it in a
benefits.
Pay scale, but not in a fixed. Pay scale and fixed pay are different.
No, fixed pay, unless you say that once that pay get revised,
Yes,
that corresponding revision is not given to you.
yes, obviously that will not be given fixed pay.
No.
Because
Not be given is one thing, but has it been given, not given, is a matter of factual finding. Mr. Nayak, what do you say?
Not to make only see paragraph 55 of that.
Oh,
Judicial.
yes.
In view of all our above conclusion, the decision rendered by the full bench in the High Court of the High Court in October is liable to be set aside, and the same is hereby set aside. The decision rendered by the division bench of the High Court in State of Gujarat versus Rajinder Singh is also liable to be set aside, and the same is also hereby set aside. We accord the decision rendered in State of Punjab versus Rajinder Singh with the modification that the employees concerned would be entitled to the minimum of the pay scale of the category to which they belong, but would not be entitled to the allowances attached to the book held by them. Wait, two things not minimum of the pay scale and two no allowances. We have given them DNS allowances also. We accept this condition. We are completing your DNS allowance.
no, there was no.
That is one.
No.
Lordship may please come to Upenda's topic. I am not holding that judgment today, Lordship.
Mr. Manan, if we want to go for a hearing, I think we take it up on a Tuesday or a Thursday. This will require
No,
consideration.
Lordship, one question, and very important question I am getting. That Upenda's Lordship made two paragraph 2 and paragraph 16. Lordship will get the issue here. Paragraph 2 and paragraph 16. The issue was whether the MR and workers employed engaged prior to 1993 can be considered for regularization of their services. That was the issue there. And it was the.
Just 1 minute, Mr. Chaudhary, there was some review petition with regard to this, if I
Yes, yes,
recollect.
my lord, no, my lord, what had happened? In vendors, we filed a review.
What has,
Now, my lord, we have to withdraw that because in the meantime, against being agreed by the decision in vendors. Two assemblies are being
okay. So they are still pending.
still paid, and we have withdrawn our review.
All right. So that is the factual position. So we'll take it up, all right, but prima facie, I think their interpretation cannot be faulted with.
Yeah, that
Prima
is
facie,
the prima facie, but
unless you want, no, unless what you want to say that by bringing you into fixed pay, they have got you a pay which is lower than the minimum of scale. Or perhaps even that interpretation is acceptable, that the pay has subsequently been revised, minimum of pay scale, but that has not been granted to me.
my simple prayer was, my simple case was basically try to. You have given us the minimum of fees.
Correct, but that is why the question,
Why you put it in a fix?
no, that is why the question.
You are giving some more benefit, or is it we are taking away something?
No, the question is, how are you affected?
Just one word from the guideline.
You must come up to say that this order has been violated
Yes.
by putting you to an unadvantageous position. In spite of this order being given.
It would have been some advantageous position, I don't think these people would have come. That is first thing.
Mr. Mannan,
Something is-
please understand the question of the court. The directions of the court are very clear.
Yes.
Now, you have to say that from regular pay scale, you've been brought to you have been brought to a fixed pay, but been given the minimum of pay scale. That is the direction of the court, both in Upendas as well as in Jagjit Singh. Now, how are you affected by the change from the whatever pay scale you are given to the fixed pay, but with the minimum of pay scale, that too with DNS allowance?
Okay, that I understand. I understand what your lordship is trying to say. What I am trying to point was the word fixed and pay scale. Pay scale and fixed pay are totally different.
Definitely, yes.
So if we can say that minimum of pay scale is also fixed pay, then I have nothing to say. But if it is said no, if what says minimum of pay scale, you pay minimum of pay scale. Why you pay?
You satisfy us that these are two different terminologies and
That I
carries-
have to bring the
connotations. Therefore, it requires a hearing. We'll take it up on whatever date.
So the genius is not sitting in the finance department.
Forget genius. Genius is everywhere except on this side. Take it from me. Yes. Now we
It's
fix a
not
date.
this side.
Let's have a date. List on 12th September. As the matter would require some consideration for admission hearing. Learned counsels, Mr. Mannan and Mr. Nayak, from the respective parties. Anyone else appearing? Mr. Goswami for
Sunny has a period for the
additional lady, assisted by Mr. So and so for water resources. All right. Joyce,
Item 22,
Still waiting is also the matter will be expected for hearing in the meantime because meetings are never complete. Only allegation that they have not received the inquiry report, all this facts needs to be verified from the records. So,
you'll admit for hearing, Mr.
yes, sir.
Our learned counsels will be part of it, submitted that meeting the company admits. This for hearing,
Records to be put.
records speak also.
The date will be fixed. He has been terminated.
Let the records come, we'll fix it.
23,
Previous page recommend of 2 PM I have filed their recommendation and they are not entitled to reply.
At the request of MS so and so, matter adjourned for 3 weeks, enabling her to file reply to the affidavit in opposition filed by Sue.
24,
Lordship and the application will be the
10 particular, ready. Yes, for a week, sir. My team, 2 months, but when my application continue. Sir, I, there and the last meeting.
Yes, who's appearing for the respondents?
There and the last meeting.
No affidavit filed by the respondent side, the respondents in spite of opportunities being granted. None appears for the respondents. Then the matter is called up. Mr. So and so appears for the petitioner. This is the matter after 2 weeks. And the respondent PWD department is directed to file the affidavit.
We have sent in for vetting, they have sent it back. But there are 19 annexes, some pages are not eligible.
Mr. Ardor appears for the respondent, affidavit not filed. You want time to file affidavit or not?
Affidavit, because of the annexes.
2 weeks on the cost of 2,000. You can give you 3 weeks, 4 weeks okay.
I will check it.
3 days. That council pays for filing the affidavit by 25th. 25th.
25.
Yes, Mr. Chaudhary.
Here I'm saving the validity of a disciplinary proceeding matter. What has happened, a preliminary inquiry report has been taken note of. Supreme Court says, my lord, we cannot be taken because in the state of the preliminary inquiry, we are not associated. The effect 2 o'clock also takes the hardly take 10 minutes time.
2 o'clock.
Yes.
Huh? For hearing, we are taking up hearing. What is the hearing?
Covered by 2 honorable Supreme Court judgment, I have got to judgment. Now it's already 1 o'clock. Can we take it up at 2 o'clock?
Or we can have it on Monday, subject to your convenience.
Now it's only.
All right, 2 o'clock. At 2.
26.
I would, this is to my right. I've been given to understand that my presentation got rejected, but lordship will see the order, my lord. Passed on the last occasion, my lord. Lordship will see the
2-8.
2-8, my lord.
2-8.
But this is my lord, just outburst. Because commissioner has been my lord. And it is similar circumstances, under petition 2 of them, they have given the amount of the. Let them find affidavit, why they have given 2 and why not 3 are considered.
As per the order of the honorable court has submitted results. Separate representation final defendant. Relying upon the OM of 1951 final. So their individual representation.
So your condonation has been not considered.
Yeah.
Is condonation.
Now, lordship similar order, madam. You will see that.
No. But what are you praying for in the?
The dissertation to be disposed of.
So it has been disposed of now.
No,
It has been disposed of final.
age condemnation, my lord, in similar circumstances and earlier, if you are not see the order. They should file affidavit, my lord. Why the 2 of them considered
You bring it on record, you challenge this, you bring it on record.
My lord, I will satisfy your lordship. Let them file affidavit in case, my lord, because there's a.
No, what is your prayer, Mr. Roy?
This is the matter. 4 years bench order, my lord. Not you will see that.
The notification which they are relying, my lord, in the in the coordinate based pass on order matter, the statement of the personal department appears to be inconsistent, incorrect in view of the notification dated, and they rely on this notification. This is simply, my lord, a problem, my lord.
We are examining the.
You belong to what category? You're what
We
category?
are working with the veterinary department, so
Ah,
only thing we are overage, my lord.
no,
Petition number 1, my lord. Even 1 day, my lord. Petition number 1 is overage by 1 day. The so application for
we come back at 2. We come back at 2. Yes.
Take that to item 25.
Yes.
wait, please. My lord, will kindly come to this showcase notice, which is at page 75. I will briefly indicate what had happened. Assam Industrial Development Corporation, my lord. They had a fixed deposit with X Bank. When the money got matured, then they, my lord, they called for some rate of interest, based on which, my lord, the decision was taken to put the principal amount in another bank where it will be giving more interest. And the whatever the amount accrued in the earlier fixed deposit, that will go to the regular current. So dispute is with regard to, my lord, this process. There is not even a single 1 rupee financial loss to anybody. It is in that context, my lord, if petitioner who was in the account section, if proceeding was initiated against him, please come to charge number 1. While functioning as the financial controller under the establishment of the SIDC, it was reported by cashier on 16/6/20 that you had arranged for transfer of money amounting to 15 crore by transfer from Canara Bank to private account of one so and so in the account number so and so maintained and operated by him in Central Bank of India, Bhangar branch, by producing fake forged letters dated so and so. And you allegedly replied to the same by your reply dated through email, intentionally with an intention to defraud and cause loss to the corporation for which you were charged for such illegal account action under solution. So, my lord, these are the necessarily basically the charges. I am not calling upon your lordship to decide on merit. Therefore, I will not trouble your lordship with the facts in details. Please come to page number 80, my lord. My so-called reply. It's part of my reply. I'm reading from the top, my lord. The Assam Industrial Development Corporation Limited had requested different banks such as State Bank of India, Bank of India, etc., to telephone or email to submit a fixed deposit rates for a period of 1 year. A total of 10 different bank rates were either given collected from their website for their fixed deposit for a period of 1 year and compiled by AHC, and on perusal of the same, it was found that Central Bank of India had offered the highest fixed deposit rate, that is 5.6% per annum quarterly compounded for deposits in the denomination of I, along with the then managing director, Assam Industrial Development Corporation, an additional financial controller, had put our signature in a file wherein it was specifically stated that amount of 15 crore will be kept as fixed deposit in Central Bank of India, and same will be transferred from Canara Bank to Central Bank of India, and balance amount will be transferred to the savings account of the Assam Industrial Development Corporation maintained in Vijay Bank. It is pertinent to mention here in this connection, on 31/7/21, the additional financial controller had put forth an internal note from his end to deposit the said amount in the Central Bank of India, which was duly approved and signed by the managing director, Assam Industrial Development Corporation Limited. So this is the background.
Then my lord will kindly come to the inquiry report. Page 88. Inquiry report on the charges mentioned in the show cause notice. Please come to my lord the heading steps followed during inquiry. Collection of available documents from accounts department of VIDC deemed relevant to the case. Consideration of replies to the show cause notice submitted by the suspended officer. Interaction with personal account department including suspended ones. Statement of procedures and etc. Now this is important. Examination of preliminary departmental inquiry conducted by the then General Manager AIC. Earlier, the corporation by its office order dated 11th of August 2000 and appointed D.K. Dekar, General Manager retired to inquire the fraudulent activities in connection with the fixed deposit of the corporation and accordingly had submitted the report on 7/11/2020. Based on the inquiry report submitted by the DM, the competent authority had issued the show cause notice to O.P. Agarwal, suspended, and C. Rajiv Mehdi suspended by later detention. So, my lord, I have brought your lordship's attention to this particular page to show that inquiry officer, while proceeding with the inquiry, did take note of, my lord, the inquiry report. Now, my lord will kindly come to the impugned order, my lord. Sorry, yes, inquiry report at page 95. Conclusion. On perusal of all the available records, statement of witnesses, replies submitted by the accused person, and after considering the findings of the preliminary departmental inquiry report, I have my opinion as well. So admittedly, my lord, the inquiry officer relies on the inquiry report, preliminary inquiry report. Now, therefore, he comes to the conclusion that petitioner is guilty. Eventually, my lord, based on the inquiry report, the termination order is passed at page 102. As per the decision of the 304th board meeting held on 29/12/21 and order of the Honorable Guwahati High Court, the services of Om Prakash Agarwal, Financial Controller, stands terminated with immediate effect. My lord, the argument which I propose to make is, my lord, very simple. A preliminary inquiry is normally conducted to gather materials. To enable an authority or the appointing authority or disciplinary authority to gather materials regarding whether, sufficient materials are there to proceed against a delinquent. Now, my lord, why preliminary report of the preliminary inquiry cannot be relied upon for the simple reason? It is a fact collection process, madam. In that process, I have no opportunity of, cross-examining the person who are examining during the course of the preliminary inquiry. Therefore, it is said, my lord, you cannot rely upon it. Now, there is no dispute that the inquiry officer has clearly indicated that he also relies upon the inquiry report. Now, therefore, in my humble submission, my lord, two questions calls for consideration. The first consideration is whether the preliminary inquiry report could have been taken note of. And second consideration is, my lord, now the fact that preliminary report was taken note of in the inquiry and based on the inquiry report termination order has been issued. How to find out, my lord, how much the preliminary inquiry report has influenced the decision making process? Is it possible to, segregate it, or as a whole the proceeding with vision? Assuming for argument's sake, my lord, Lordship comes to the conclusion or accept my contention, my lord, in which case Lordship will remand the matter to the authority from the stage of, my lord, inquiry. And in the meantime, I will be under dim suspension. That is the proposition of law in view of the decision in Nelson notice. My lord, I will rely upon two judgments, my lord. One is 2013 4 SCC 301. I've given.
Yes.
Please come to my lord, 2013 4 SCC 301 para 41 at page 318.
Yes.
In the aforesaid backdrop, we have to consider the most relevant issue involved in this case. Admittedly, the inquiry officer of the High Court on administrative side as well as on the judicial side had placed a very heavy reliance on the statement made by so and so, so and so, so and so in the preliminary inquiry before the vigilance officer. Therefore, the question does arise as to whether it was permissible for either of them to take into consideration their statement recorded in preliminary inquiry, which had been held behind the back of the appellant and for which he had no opportunity to cross-examine either of them. A constitutional bench of this court in Amarinda Guha versus Northeastern Railways held that purpose of holding a preliminary inquiry in respect of a particular alleged misconduct is only for the purpose of finding a particular fact and privacy to know as to whether alleged misconduct has been committed, and on the basis of the findings recorded in the preliminary inquiry, no order of punishment can be passed. It may be used only to take a view as to whether a regular disciplinary proceeding against the delinquent is required to be held. Similarly, in Sampaklal, a constitutional bench of this court, while taking a similar view, held that preliminary inquiry should not be confused with regular inquiry. Preliminary inquiry is not governed by provisions of Article 11(2) of the Constitution. Preliminary inquiry may be held ex parte for it is merely for the satisfaction of the government, though usually for the sake of fairness, an expansion may be sought from the government servant even at such an inquiry. But at that stage, he has no right to be heard, as the inquiry is merely for satisfaction of the government as to whether regular inquiry must be held. The court further held as under. There must therefore be no confusion between the two inquiries, and it is only when government continues to hold the department inquiry for the purpose of inflicting on the government servant one of the three major punishments indicated in Article 10(11), that government servant is entitled to protection of that article. In Narayan Daktalai versus so, it was held as under. A preliminary inquiry has nothing to do with the inquiry conducted after issue of the charge sheet. The preliminary inquiry is only to find out whether disciplinary inquiry should be initiated against the delinquent.
So essentially, you are saying that
Yes,
preliminary inquiry relied upon, therefore the inquiry.
yes. My lord, kindly have a look at para 45. That's very important.
But subsequently, I think it is a judgment.
No, my lord, this view has not been altered. Subject to correction. In view of the above, it is evident that evidence recorded in preliminary inquiry cannot be used in regular inquiry, as the delinquent is not associated with it, and the purpose to cross-examine the person examined in such inquiry is not given. Using such evidence would be violative of principles of nature.
Now, if during the course of inquiry, if that report of preliminary inquiry was confronted to the delinquent,
Yes. And I am given an opportunity of cross-examination. No, my lord. The preliminary inquiry report cannot be used for the purpose of regular inquiry, if I have understood the correctly the judgment. It says, my lord, the purpose of a preliminary inquiry is only to find out facts, enable the government to take a view whether in a given case disciplinary proceedings should be proceeded with or not. The idea is very simple, my lord, because the delinquent have no opportunity. For example, my lord, during the preliminary inquiry, supposing testimony of some people are taken. Now, those people are not subjected to cross-examination. In law, my lord, a person, if he deposes unless he, make presence himself,
opportunity is
there is no evidence.
opportunity of proceeding.
Now, therefore, the second point, which in my humble submission would arise for consideration. Now, how much the preliminary inquiry has influenced the termination? How much other factors have? Whether it is possible to, my lord, solve this issue. There also Supreme Court has said it is not fine. My lord, 1955, AR 1955 Supreme Court, 271. AR 1955 Supreme Court 271, para 9. My lord, it's a different matter nowadays after amendment of the National Security Act. Even one ground is good enough to maintain the, but provided it must be able to, my lord, ascertain that this much opinion, this much influence the preliminary inquiry report made, this much influence the other factors made. Para 9. The learned Attorney General frankly considered that it could not be denied to a certain extent. The tribunal had drawn upon its own imagination and had made use of number of surmises and conjectures in reaching this result. He, however, contended that eliminating the irrelevant materials employed by the tribunal in arriving at its conclusion, there was sufficient material on which finding of fact could be supported. In our opinion, this contention is not well founded. It is well settled that when a code of fact acts on material partly relevant and partly irrelevant, it is impossible to say to what extent the mind of the code was affected by the irrelevant materials used by it in arriving at the finding. Such a finding is vitiated because of use of inadmissible technique.
I think this view perhaps will slightly altered, perhaps.
Okay.
I'm not.
But yes, certainly nowadays in case of National Security Act and all, yes, that's correct.
No, it's only in some revenue matters. I think income tax.
Subject to correction, now maybe. Now here in this case, my lord, I'm sure Lordship will appreciate that. Where is the question scope of my lord allowing them to rely on the preliminary inquiry report? Therefore, the matter should go back. I'm not saying Lordship will pause the proceeding for all time to now. The matter should be remanded back to the AITC, the disciplinary authority, and I will be under the suspension and they will proceed from the stage of inquiry. Of course, because of Lordship will be interfered with the intermission, I will be entitled to some money by way of subsistence allowance. That's all. That is my humble submission.
Yes.
In this case, so far, the rely upon the preliminary inquiry is not mentioned. The inquiry was done accordingly as per the procedure.
No, kindly come to page 95.
Yes,
There is a finding of the inquiry report on that. Conclusion
yes,
that he has relied on the preliminary departmental inquiries.
before this motion, I would like to go to the first page of the inquiry. First of the inquiry report. Step forwarded during the inquiry.
Page number?
Collection of,
Page number?
yes, page number 88 in the inquiry. Alex Azim.
Yes.
Step followed during the inquiry. Collection of available documents from the account department of the AIDC is relevant to this case. This is the first. Second, consideration of the reply.
Mr. Chaudhary has taken us through this.
Yes,
He says one of the items is the examination of the preliminary department.
Yes, Lordship, this is the examination, not rely, Lordship.
For what purpose will it be examined?
Lordship, consideration of his reply. The so cause was issued.
Mr. Goswami, case of the petitioner is that you have no doubt relied on all this. He has not raised any other issue. His only grievance is in view of the judgment of the Apex Court that the reliance on this number 5.
That report was not relied upon. It is considered.
It is returned.
Yes.
It's reflected in page 95.
Yes, 95 it is stated. Lordship,
After considering,
on perusal, yes. It is considering. Lordship.
what is the meaning of that?
It's considering this when considering the reply of the petitioner. the inquiry officers must go to the findings on the basis of which the so cause was issued.
This is consideration of the preliminary departmental inquiry.
But all the proceeding of the inquiry was.
You are not answering the question of the board. You go through the judgment if you have not gone through.
Yes, the judgment is categorically stated that rely upon. Not part for
So
consideration.
you have to distinguish what is the difference between rely and consideration.
Yes, the consideration means so far, for both show the reply of the petitioner, because the so cause was issued to the petitioner on the basis of the facts findings of the preliminary inquiry. And
So essentially what you are submitting is,
yes,
whatever way you want to submit, that there could be a case where if you are able to demonstrate that that part of the departmental inquiry, preliminary departmental inquiry can be segregated, even then the inquiry report on its own
yes,
will stand.
yes,
Now this, Mr. Chaudhary has placed on a judgment of the, I think it's a constitution bench.
yes, madam.
Constitution bench judgment.
No, that judgment, because if it is stated that heavily relies.
Oh no, 1955. 1955 judgment where it says that this partial thing you can do. If you have relied on, order goes.
No, not relying.
Considered.
Consider he
Why did he read?
yes, because to verify his reply also.
No. You see, the preliminary is for the authority, disciplinary authority, to decide whether a proper departmental proceeding is necessary or not. Once they find that yes, there is something hanky-panky going on, they appoint an inquiry officer, they give him charge, presenting officer, and he carries on. Now that report, even if it is there, the inquiry officer will have to give return a finding. They are notwithstanding this report. These are the materials on the basis of which I return the finding.
Yes, Lordship. It is specifically stated, Lordship, in every charge, if the Lordship will peruse the findings of the charges in the inquiry report, Lordship, it is categorically stated on the basis of the evidence, Lordship, basis of the documents, Lordship.
You go through the judgment, Mr. Goswami, this judgment will have to be relied upon, they're binding on us. If you want to distinguish, then you have to distinguish on facts properly.
I'm not good for that.
You have to go through before you start your arguments. His entire case is based on the judgment, on the law. Do you have a copy of this?
Lordship, I have to explain, Lordship.
Mr. Chaudhary will take it up on Thursday or some other day.
All right.
Keep it on 17, let us see. You come back. Hard learned counsels for the parties. This petition has been.
Instead of 17, could it be possible only can you accommodate me in the second?
If 17 is not convenient, we can take it on some other day. If it is. Tell us. Hard learned counsels for the parties. Case urged by the petitioner is that the inquiry officer relied on the preliminary departmental inquiry, and which is evident from the conclusions arrived by the inquiry officer, read with the steps followed during the inquiry, where examination of preliminary departmental inquiry conducted by the then General Manager AIDC is also reflected. So, Mr. Chaudhary, London Senior Counsel submits that this finding, this conclusion of the inquiry officer by placing reliance on the preliminary departmental inquiry is contrary to the law laid down by the Apex Court. Therefore, the inquiry report needs to be suitably interfered with, and the matter may be remanded back for a fresh inquiry. Stop. He has relied on the judgments of the Apex Court in AR 1955 Supreme Court and 2013 4 SCC to buttress his arguments. Mr. J.K. Goswami, learned Standing Council,
Yes.
AIDC. Submits that matter be taken up on another date for him to reply to the arguments made by the learned counsel in the petition. Accordingly, matter is deferred and fixed on
24th, my lord.
24th of August for admissions.
For further hearing.
Further hearing. This copy you can keep it. We have an extra copy, you can give it to
I've
Mr.
given it.
24th for further hearing.
Item number 26.
And to advertise it, you can do that. I will see the prayer in the edition.
Prayer in the requisition.
It is therefore, the last report page 16.
16. Yes,
It is therefore paid that the lordship will be pleased to take this petition for the response and issue rule upon the respondent of the report as to why she is of nature of matter and or any other reputed further or directed shall not be issued thereby. I think the respondent approaches to allow the petitioner to participate in the selection process initiated as per the advertisement number 13 of 2002 dated 27/7/2022 issued by APC by relaxing convening the age limit on the basis of experience. B, directing the responsibility to issue necessary notification by around reasonable age relaxation. Convention on the basis of respective service experience of the petition and upon so. So this is the prayer manual. And interim the director responsibility to provisionally allow the petition to apply for offline orders. Because it was pursuant to the same advertisement, that is 13, number 13 of 2002, dated 27/7/2022, issued by please to pass such order or measures. But thereafter, one post was kept vacant, my lord, and they have been provisionally allowed them to appear in the exam. And thereafter, the final result were declared, my lord, whereby, my lord, the one post has been, result has been vacant, my lord. We don't know who the petitioner, my lord, in that particular part of the post. Because the result, I have given an application, my lord.
now. Your affidavit,
No affidavit filed, my lord.
when you file your affidavit,
They should file their affidavit, my lord. That's what we are.
On the last petition, on the court, get us to dispose of the their representation. We have already considered the representation of the personal department, whereas the other petitions were, in the other petitions, the personal department view was not considered and asked all the petitioners to their representations as per the OM of 1951. So they have submitted their personal representation. And in this matter also, after the order of this order report on the 2nd of August, we have already considered them as per the OM of 1951 also. And then also after considering their joint representation, we have coming on this fact that here they should not be condoned by the.
Okay, let me read the order, my lord, to 8/2015. But, may I read, my lord? May I read, my lord?
no, it's a longish order, you read the relevant paragraphs. Okay?
Relevant paragraph, my lord.
So there was some representation given
Yes,
that the authority was held to have been sitting over it. And therefore, they were directed to pass that order.
They have, my lord, that commissioner has taken it personally, my lord. Because of that, he has rejected it, my lord. Lordship will see the.
So whatever it is,
My lord, let them file affidavit, my lord, I'm saying that.
so in terms of the directions of the court, the representation has been rejected.
disposed of my lord.
No, this was in the rejection.
Rejected.
Disposed of my lord, as per the order, my lord.
Well, can they do it, my lord? And what is the ground? In
The ground is we have already considered all the representation in the light of 1951 OM, my lord. We have considered.
I place the order, my lord.
Now, what is your age?
I'm one day, my lord, petition number 1 day, part by 1 day,
1 day.
1 day. Only one.
No, what is the upper age limit?
38, madam. 38.
38. You're for your unreserved category.
Just 1 day, madam.
You're unreserved.
Unreserved.
Now, according to the notification, what is it? According to the personnel department circular, relaxation of age.
Well, 5 years, madam, that we have paid, madam. Lordship may see that I place an order, madam, 28 to 2022 of the court year bench, madam. WPC number 5350 of 2022. Lordship may see that.
No, have you enclosed that notification? Is that notification enclosed? Relaxation of age?
That Lordship may say that order of the in WPC number 5350 place it, madam.
Where is that order?
That I
5350.
5350 of 2022.
Yes, what is stated here?
Lordship is 2022.
Yes.
Lord Mr. A.K. Sharma, learning for the petitioner. Lordship may speak that, my lord. Number 2. All the petitioners herein intend to participate in his election process pursuant to advertisement date number 13 of 2002, dated 27.
You can come to para 4 straight away. Or para
A
3.
reading of the aforesaid expected contents of the paragraph 4 of the affidavit in opposition of the personal B department makes it visible that it is the view of the personal B department that apart from provision that upper age limit is 38 years for general candidate, 43 years for SC/ST category candidate, 40 years for exciseman candidate, and 48 years for persons with benchmark disability candidates. No further provision of age relaxation is available. The safe statement of the personal B department appears to be inconsistent and in view of the notification dated 3/5/91, which is provided as a particular procedure for relaxation of upper age limit in given individual cases. It is also noted that the notification dated 3/5/91 51 has been accepted by the judgment of this court in dated 3/8/15 in WPC number 8545/14 and others. As per the as there is a provision of law of relaxation of upper age limit, we require the petition to file.
All right, we've seen it. Madam, what is the meaning of the last line in the second paragraph of your order? Rejection order. Rejection of the representation, second paragraph. Peruse the order. You read the last line, last sentence on examination.
Communication appears that the petitioner signed by the petitioner that mentioned above was rejected as per OMJ 1951.
Who rejected it?
The department, my lord.
Earlier.
No, earlier also it was rejected. Now, my lord, it was re-examined after the order of this honorable court on 2nd of August. Then we have rejected in the light of the 1951.
Now you are required to examine this in what terms?
My lord, they have annexed their, in the petition, they have annexed their representation, my lord, in page number 58. I mean, page number 58, it's a common representation, my lord.
Do you have that notification of 1951?
Well, I do have that.
It will be available in that writ petition, earlier writ petition.
This is the panel.
That WPC
Yes.
845.
I have the judgment. This is the judgment, my lord.
So in that, I believe the notification is extracted.
I'm saying it's taking your part. Yes.
Other restitution, in all the other restitutions, it was on that ground only, and
What ground? What ground?
on the ground that my lord, whether individual representation should be given on their individual ground, relying upon the 1951 OM, my lord, and all the hierarchy.
And what representation was filed here?
Yes, I think 6 or 7 representations, 5 out of them.
No, in this petition.
In this petition, only common representation is there, my lord.
Which one? Page 58.
Page 58, my lord, 2 representations, my lord, one is a 61, my lord.
So what is the difficulty in taking their cases individually on the basis of a common representation?
My lord.
What is the difficulty?
No, my lord. We have not.
Then?
But it is not. We have considered this representation.
You have
My lord,
not.
but it is not relying upon, my lord, or upon relying upon this 1951 when we can consider this representation, my lord.
You want, I'm sorry, you said what?
My lord, only relying upon the 1951 judgment, we are not complying with the representation provisions of 1961, my lord, as per this, they are representation, my lord.
So what, where is the 1951 way?
Is there, my lord, para 27 of the judgment, because actually, para 27. In copy of the para 27.
27.
27, copy of the government notification dated 3/5/2051 could be placed with handbook of general circulars of government Assam. The same notification quoted, general rule restriction of age limit. In pursuance of the provisions of Article 309 of the Constitution of India, Governor of Assam is pleased to make the following general rule regarding relaxation of the age limit for recruitment to civil services or civil posts in connection with the affairs of the state of Assam. Notwithstanding, anything to the contrary in the rules regulating the maximum or minimum age of recruitment to a service or post in connection with the affairs of the state of Assam, the age limit may be relaxed in favor of any candidate or class of candidates.
So you did not, you disposed of their representation without reference to 1951.
We have mentioned, my lord, in the para, my lord.
So what is the meaning of that? That is what I was not understanding. That is what I wanted you to read. What does the commissioner want to convey by this sentence? What do you understand?
Consider this representation as per that word. As the other candidates were.
It's not written about other candidates. Kindly read the sentence, again. On examination, it appears.
On examination, it appears that the petition signed by the petitioners as mentioned above was rejected and for going with it to reach 5/1951 issued by personnel department.
So there was some earlier order rejecting their applications.
My lord, the personnel department view on the basis of the personnel department, we have already rejected their representation section, my lord.
Earlier,
Earlier.
this representation was rejected on which date?
The paragraph, one of the order, my lord. As the personnel department view was not considered by this honorable court in the other applications, now we have considered this memorandum. This applications in the light of 1961 or
What you are submitting and what is reflected from this is not in sync. Kindly read it and then explain to us that this is the interpretation of this order. From what I understand is their joint petition was earlier rejected. Rejected by whom?
rejected by the department, my lord, rejected by the department for.
Where is that order?
Order the personnel department which is reflected in the.
It's not by rejected by personal department. Why will it be rejected? Where is that order by which it was rejected? We are wasting time, madam. We call your who's responsible for here. Secretary. No, your affidavit, what will you file? What will you file in the affidavit? It's a simple issue of considering their application in terms of 1951. If it is permissible, not permissible, not permissible, you write a cryptic order which even you are unable to understand. You understand, you tell us what is the meaning of this order. There is an order of this court directing them to comply with this order within 5 days. This order was passed on 2/8,
Yes.
so you passed this order on 8/8. Exactly after 5 days. Now you pass an order which you are unable to explain to us what is the meaning of this order. We know no, the last sentence says the petitioner representations are hereby disposed of. Disposed of for what? In what manner?
Disposed of on rejection, my lord.
Rejection, why?
And they have not complied with the OM of 1951.
Who is supposed to comply?
The petitioners, my lord.
Why? Why? What is the compliance given in 1951? What is the requirement in 1951?
Similar petitions were in that same way, so. The other petitions.
Madam, you at the cost of reputation, you are a counsel of the court. You are an officer of the court. So you have to be clear on what instructions you are receiving and what you like to submit. You are not employed under the veterinary department. So if the instructions are not forthcoming, then you tell us what orders you want from us. Your order says that this representation is rejected as per OM 1951. How has it been considered? It's not reflected here. You can't have knowledge because this is as per record, as per instructions.
As per instruction, my lord, the representation was rejected of the.
So where is that order? Where is that order? Where is that rejection order?
It was in the office, so I have, my lord, I will submit the order, my lord.
So if that was rejected, then why did you not file a review against this order, last order, that it was already considered and rejected?
My lord, there's the personal and his petition was, application period rejected of the personal department view, and in other similar petitions, that personal department view was not considered. On that view only we are now thinking that we are.
What is that view? Where is that view? Where are all this information?
I can activate my lord in that case for detailed rejection order, my lord. One week time.
MM Kotoki, learned standing counsel, veterinary department, prays for it is granted 1 week's time to bring the stand of the department in respect of the rejection order stated to have been passed on the representations preferred by the petitioners and in pursuance to the orders of this court dated 2/8/2023. The affidavit be positively filed within a period of 1 week. And copies thereof be served on the counsel for the petitioners. List after 2 weeks. Let their affidavit come.
The one post is vacant, that is.
Is there an interim order earlier?
Yes,
Earlier,
yes, one post is vacant.
interim order passed earlier.
Interim order, it's got no interim order passed,
Then
but one post is been, kept vacant, my lord.
My lord.
if it is kept vacant, it is vacant. If it is not, it is not. I mean, we cannot pass an interim order today. There's some interim order passed.
In order to appear before the interview.
Here is the matter result, my lord, I've given the result, subject to.
You are asked to participate.
Yes,
Yes, my lord.
So that interim that you have been allowed.
yeah,
Yes,
And your lordship says that subject to final outcome of the High Court order, that they kept one post vacant.
very well, it is up to them. They've already kept it vacant.
Item number 27.
Okay.
From the department. Therefore, to which extent I had related.
Mr. So-and-so learned counsel for the petitioner prays for and is granted 2 weeks time to file reply. To the affidavit filed by the respondents. Please start with notes.
28.
Can you, along with some time to file and getting reply also?
At the prayer of learned counsel, I miss so-and-so. Matter stands adjourned for 2 weeks, enabling her to file reply affidavit. Mr. Doctor appears for respondent number.
Twenty-nine.
Lordship, the respondent will file one application affidavit very recently. We like to file a reply to that.
Same order.
Near the matter will be otherwise it was not on the last occasion. Near the date we fixed to Lordship on 22nd.
You file your reply first, then pray for a date. You've not even filed, not even served date, you want a date. And when the matter is fixed, you want time. Today is a date fixed, no,
Yes, Lordship, yes.
then
So, filing the affidavit.
Only one is the, we can't know this receipt to subsequent review or substance no particular date. One was with the big, one part of February to plan when it take. Currently, it was weeks in that part of the government. Time. You are filing the affidavit and then mounting on the record. But
very well, after 2 weeks, yes.
Item 30.
This case, your lordship, patient two issues, your lordship. Wherein there is a non-payment of area salaries amounting to this 4,72,000. And the other issue is that if he is also having the promoted to the post of manager while serving is a capacity of LDA for last more than 33 years. your lordship.
Someone who wants to file an affidavit,
Which similar matter is based on 15th of September.
similar matter,
The matter will be titled on.
Mr. Borwa,
So the regarding the promotion or responsibility of adding the disposal regarding the disposal payments. The issue, that is, again, open.
you produce the order, give an order, you give the numbers to him, let him check up. Let him check up, if he agrees, then we can do it.
Yeah, this regarding the taken out another day, your lordship. Then.
All right.
Then if they have pushed the file, affidavit.
After 1 week, the joint request.
31.
There was the affidavit. That was the disposal matter on which I think that the government will place it before the DMC.
It has not been placed at all.
But then we don't know whether they have not communicated anything.
Where is your application?
Last time, whether it was sent over on page 30. The DI office of the DIGP mother sent the page 30. Nineteenth of September 2022.
Heard learned counsel for the parties. Mr. Or any information? No.
Look at the employees of my lord, record number 4. I am appearing for my lord.
Who is supposed to place it before the DLC? Who is supposed to place it before the DLC?
Secretary Home.
Who appears for secretary home? Hmm?
And one more thing, I would may I point out, there is
From three sides. We put together on four sides. So far, you have not taken the kind of instruction either from the moving department or the police. I see some kind of.
Heard learned counsels for the parties. This petition is filed by the petitioner. Taking compassionate appointments. As his father. Died in harness while in service. So father of the petitioner was working as. What was he working? Serving as an inspector of police. Inspector of police.
Inspector.
And he died in harness on 5/3/2009. The petitioner filed his application. The elder brother of the
Yes,
petitioner
first elder brother was considered, he died again.
filed an application for compassionate appointment on 24/7/2009. However, he unfortunately expired. He expired after
Getting selected, after SLC was, SLC has cleared his name.
his elder brother was recommended for appointment by the DLC and considered subsequently by SLC, but unfortunately he expired before he could join. Stop. The elder brother expired on 25/6/2015.
Yes.
So who filed the application? Mother, not the petitioner. Petitioner is the mother.
No, son, through his mother, it was filed.
No. Where is that application?
Page 23, 4/7/2015.
Thereafter, the mother of the petitioner filed application for appointment of the petitioner on compassionate ground by application dated 4/7/2015. So the said application was stated to be filed, was received by the competent authority, and thereupon matter was processed, stopped. However, petitioners have not been informed whether it was considered or rejected by the DLC/SLC. Stop. No information is forthcoming from the department in respect of the status of the application filed by the petitioner's mother on the behalf of the petition. Under such circumstances, the petitioners have approached this court. Mr. D. Boral and counsel for the respondent submits that he has not received any instructions. Considering the fact that no instructions are forthcoming from the department, and considering the limited prayer of the petitioner, the petition is disposed of in the direction to the DGP, who is supposed to place it.
OPG plus DIG people. To the secretary of the yes.
The secretary home. No, not secretary home. The respondent number 3, Director General of Police, is directed to place the application of the regarding compassionate appointment of the petitioner before the competent, before the concerned DLC or the SLC as the case may be, and thereupon, if any, stop. However, if any order has already been passed by the DLC over the SLC, the same be communicated to the petitioner. Stop. In the event no such orders are passed, Commissioner Given, Director General will place the application before the DLC or the SLC as the case may be, and the DLC or the SLC will thereupon pass necessary orders, and copies thereof be furnished to the petitioner. Stop. The petition stands disposed of in terms of the above. The directions above shall be carried out in 60 days from the date of receipt of the certificate of this order. Petition disposed of.
Item number 32.
Yes,
Your lordship, previously on the subsequent dates. The various orders that reflect that the other side was directed to verify that whether the case is at par with the Ayush Kumar which was finally decided by the court.
same.
Same.
All right, heard learned counsels. Where is the judgment? Ayush Tomar. Where is the judgment of Ayush Tomar? Yes, we have it. Yes. Heard disposed of in terms of Ayush Tomar. Disposed.
Unlike.
On orders item 33.
Notice the representation in terms of order that is significant for the 17. The order is complied, has been complied with.
Do you have the order? Do we have an order?
Yes, sir.
Give it to us. None appears for the petitioner on call, Mr. So-and-so appears for the respondent. This contempt petition was filed alleging willful disobedience of the order dated 25/10/2017, passed in WBC number 3426 of 2017, whereby the writ petition was, whereby the following order was passed. Extract number 6. Stop. Today, when the matter is called up, Mr. So-and-so, learned counsel to the petitioner submits that by speaking order dated 12/4/2018, the representation of the petitioner has been disposed of, and in that context, the order of the court dated so-and-so, passing WBC so-and-so has been complied with. A copy of the representation, a copy of the order dated 12/4/2018 is retained in the case reports. In view of such statement, taking note of the statements made by the, taking on record the statement made by the learned counsel for the respondents, consultation stands closed. Notices issued are report.
Starting board.
Yeah, please, madam. Well, this is the petition for restoration. Madam.
Restoration.
Yes, ma'am. As per order dated 27/4/2022, my repetition was because of details of non-prosecution.
Any objection? Restored. Repetition restored. I disposed of, repetition restored to life. To be listed after 1 week.
Objection.
35,
Restoration order.
Hospital content is available.
David, service report. Service report is awaited. Service report is awaited. David, service report. Urge Mr. Kitan, that will council. Service report awaited might be listed after 3 weeks.
36,
May I please be adopted? This content has been filed in not even non-compliance with the honorable court order.
Which order?
Your lordship order is in page 11, annex 8.
What is the direction?
Para 8,
What is the direction?
directed, para 8. As HSL marks of the corresponding number 5 has been included in the comparative statement. At page 14, annex B to the writ petition, we directed the selection committee who has prepared the state comparative statement to also include the marks of the responding number 5 obtained in the HSL examination and add to the total marks of the responding number 5. And thereafter submit a modified comparative statement to the director for its approval. If the total marks of the respondent number 5 already obtained in comparative statement when added to the marks in the HSLC examination would be more than that of the petitioner, the director may pass appropriate order in favor of the respondent number 5. And if it is less, the total marks of the petitioner to be the first in order of the merit shall be retained and selection of the petitioner be brought to its logical and by issuing necessary appointment order. The requirement to be done within a period of 1 month from the date of the receipt of the certified copy of this order.
Hard learned counsel for the petitioner, this contempt petition has been filed alleging willful and deliberate disobedience of the order dated 25/12/2022 passed in WPC number so and so. Issue notice, petition number 4 weeks. Steps on respondents by registered post within 1 week from today.
37,
This is the order, violation of order part is content based. That is base 18. We limit to 17. Whereas this.
Paragraph?
Paragraph 6/17. The requirement of this order be communicated to the government in the.
This is a contempt petition. Then you want to file a contempt of a contempt.
It can be closed, but nothing has been done.
Then you go and review if possible. Court has recorded a finding, we do not find any deliberate and willful violation. Para 5.
That is, but because the grade pay was, he is entitled grade.
We are not on that. Your court has returned a finding. You either you see your remedies available against this. You want us to file a contempt of a contempt.
However, there,
No.
observation is there.
You show us from the provision under the act that this direction will ensure further contempt if not complied with. Maybe it might, but not in this form. You want to withdraw or will you dismiss it? Mr. No Liberty, Mr. Kandakar Learned Counsel to the petition seeks to withdraw the contempt petition file. Petition dismissed on withdrawal.
38.
In this case also,
Same thing.
same thing, content was closed, but case 50,
Then,
case 50, paragraph 5. There no content is created. We'll put back there.
contempt petition is closed. What can be done? Same order.
39.
We have given a written statement, but the party indicates the in regard the written statement.
You appear for whom? Petitioner. So some affidavit is required to be filed.
Instruction is in my hand, but I only some records in the hand. I want to reflect that was 1% certificate issued by the cities. Petitioner and there are two certificate issued by the school of finance. There is
You file your affidavit, whatever you want to say, why don't you file your affidavit? You have been granted time to file affidavit.
okay, madam. I will
Mr. What is your name?
be
Mr. So-and-so, Learned Counsel appearing for the water resources is granted 3 weeks further time to file affidavit as prayed for. So your name? Your name?
I'm appearing, proceedings are appearing on behalf of, G. Sharma,
Your name, we want your name.
CN.
Mr. So-and-so, Learned Counsel appears for the petition. List after 3 weeks.
Yes, madam.
Item 40.
Yes.
I issue efforts for consideration in this petition also, whether an administrative order passed disregarding the observation made by the honorable court is sustainable in the eyes of law. and order. So, matter pertains to your lordship appointment of legal advisor in the PCP and India for Amrut Methodist lordship. And this is third round of litigation. Lordship will kindly come to page 23 lordship. In the first round of litigation, lordship observed that if the state respondents take a decision not to act upon the select list, results for the same would have to be given. This is the specific direction lordship. But while issuing the improved order lordship, at page 31 and 7, no reason has been cited lordship.
Selection, cancellation of what?
Cancellation of
Select list.
select list lordship.
Now, where is the select list?
Even to proceed, page 70 annexure 2 lordship.
Where is your name?
My name appears as serial number 2 lordship.
So how many posts are there?
There are one post lordship.
Then,
My entire case raised upon the law laid down by the Supreme Court lordship in the case of East Coast Railway and others, versus Mahadev Apparao and others, reported in 2010, 7 SCC 678. Right. It comes to press 50 votes.
Page 15, para 15.
Para 15 votes. To the same effect, in the decision of this court in UT of Chandigarh versus Dilbag Singh, where again this court reiterated that while a candidate who finds a place in the select list may have no vested right to be appointed to any post in the absence of any specific rules entitling him to the same, he may still be aggrieved of his non-appointment if the authority concerned acts arbitrarily or in a malified manner. Yeah, Lordship authority acted malifiedly.
No, but what is your, you don't have an indivisible right, but there is one post, you are at serial number 2. Is it a case that the number 1 for some reason was not selected or has refused to join?
Lordship observed that the reason must be given.
Have you challenged? You did not challenge the select list. Select list was not challenged earlier.
Lordship, I am seeking a logical conclusion of the entire selection process. Lordship.
Did you put to challenge this select list, page number 17?
Lordship, there is no,
Was it challenged earlier?
in my humble submission, Lordship, there is no question of assigning the selected. Lordship. I am seeking a logical conclusion of the selection process. Lordship. So, no Lordship directly.
How does it matter logical conclusion? You are not selected as number 1. So either you have to be agreed by the select list to say that the selection process is not transparent, is that, and you want to challenge the select list.
Earlier on first round of litigation, Lordship, I sought a direction from the Honorable Court to pass a direction to act upon the select list. Lordship.
Where is that direction?
Okay, kindly come to next are 5 plus 21. Lordship. This is the order passed by your Lordship in the first round of litigation.
Okay. Now this is for issuing notice.
Lordship.
Page number 29.
Annexure 5 plus 21 the judgment passed by your Lordship and relieve it page Lordship plus 23 and 24 Lordship.
Okay.
Page 24 the advertisement having been issued on 18/8/2020 and the select list issued on 4/9/2020.
Sorry, so you are reading from page number
24 Lordship.
24. Okay.
Direction for Lordship. Now state respondents are directed to take a decision as to whether they are going to act upon the select list issued on 4/9/2020 within a period of 1 month from the date of receiving the certified copy of that. Prior to that, Lordship observed that if the state respondents take a decision not to act upon the select list, business quota would have to be given. Please have the
Where is that? Where is that?
page 23 Lordship. Last line Lordship. This order was submitted before the function authorities Lordship. And to the utter surprise Lordship, the authorities were sleeping over the matter till the month of March 2023 Lordship. So I filed a contempt petition Lordship before this honorable court, and your Lordship was pleased to issue notice in the contempt proceeding. Lordship will find the order. Page 29 annex 7. So this order was passed on 5/4/2023, and surprisingly on 10/4/2023, the respondent number 2 sent a letter in the WhatsApp number of the petitioner Lordship, conveying that entire selection process has been cancelled. But that include Lordship will find at page 31 annex 8. Though Lordship observed that reasons must be given, so this letter does not indicate that any person reason has been cited. Merely observe that the decision in the meeting were also produced by the Principal Secretary of the Government of Assam, Health and Family Welfare Department. In view of the above, just select list issued and so published by number so and so dated 4/9/2020
for the aforesaid recruitment to the temporary position of legal advisor arising out of recruitment process initiated by letter number so and so, hereby stands cancelled.
So this is the reason order.
No reason has been cited, Lordship.
The reason.
For cancellation, Lordship.
No. Sufficiency of reason is one thing. And indication of reasons is quite another thing. Court said we must give reasons. The reasons are given. You, according to you, may not be sufficient. It's a different. It will require examination. It's a different issue. But you can't say that no reasons are given.
Lordship, better, Lordship may put the letter in the next week, Lordship. I will apprise to someone who.
What do you want to apprise us?
I requested one senior counsel to appear on behalf of Lordship.
All right.
That will come up in the next week.
You will have to satisfy the court your right to the selection list. You are at number 2. At the request of learned counsel for the petition, the matter stands on the head for 1 week. MSA for it is for NHL.
Let me kindly be given Lordship there.
Your senior counsel will have to give a date to appear
On what is the Lordship?
on Wednesday. All right, Wednesday, 16th.
For admission, item number 50.
Yes, Mr. Sukiya.
Before my learned friend says something, I would like to draw your lordship's attention. We have but one order. They have not complied with again. Period. Order is the 3-8. That day, lordship, I will just help to recollect
Yes.
that they could not produce any document, they could not produce any list showing the names and the marks of the so-called person who participated in the category of physically disabled persons. And therefore, lordship wanted that why is no record. And lordship wanted also that the personal attendance of the director may be made here, we told you. And therefore, the day, at the request of the learned counsels for the department, lordship granted the time. This the matter again on 80, on which day the learned counsel has assured the court that all the relevant records pertaining to the selection procedure in which the petitioner has participated will be available. The records must contain the marks obtained by the various candidates, including the petitioner and other similar candidates who may have applied under the category of persons with disability. Last time my learned friend took time. We continue. Now, whether he's having all the.
Yes, Mr.
So I have is, within this time, I will go through it. Why record is not produced, it's a private thing. We had under the I'm not. May I read it?
Yes.
Can I just? When I'm going to clarify the subject as a goal, I would like to get records participate advertisement parties that has been formed, they were seen by the evidence and 80% of the India. CG is along with the other main okay. Okay, there. As per guidelines issued by the 915 intelligence was considered for Havana. Copy is the guideline. It may be mentioned here that by roster point anomalies on the basis of marks obtained by the candidates in the supervisor.
last couple of marks, you will see in the particular 32. The petitioner obtained 17 marks out of 75 marks in the internet examination. Therefore, she was not selected for final examination. It may also be mentioned that Director of Social Welfare Assam had appointed 19 numbers of supervisor and 3% reserved for physical handicap in the year 2015 under the person with disability under the Act 95. Therefore, no candidate selected under the category is by 24 2014. So, Lordship, now it is clearly as a physically handicapped person. Both the person, both the family say in petition is record has been seen by the reference from the 2016. Now, both has directed the safety certificate.
I kindly come again. Last paragraph, what is the meaning of that? It may be mentioned. Then last.
Yes, 19 numbers of supervisor under 3% of physically handicapped person have already been appointed in 2015. 30% already appointed 9%. So these advertisement they have to fill up post from the 3%. And now the petitioner is concerned.
No. Petitioner is for which advertisement? 2014.
2004. But he put it
2014.
14.
Then you appointed 19 persons in 2015.
50.
Pursuant to some advertisement.
Some advertisement, yes.
Where is that advertisement? Which date?
Advertisement is posted. Yes. Our application signed by develop Devidas. Developer Devidas, Director of Social Welfare Division. Now is Devola Devidas.
Yes.
Prediction of two. The petitioner respect to the exclude that the reservation is not for a complete visited to ensure and 95 years celebrated in the district of the right stand in respect of the post advertised. The selection of the in advertisement dated 24 February 2014 and petitioner and no other candidate with physical handicap category was participated for the principal supervisor as reported by E. Gramin Service Private Limited, which was engaged for conducting the research. That's what is coming to NXI. These has been not no personal even petitioner did not submit as a typically handicap person. It is about page 3 next A. 17 page 2019. They conducting the examination. In reply to the appointment of affairs, I would like to inform you that as per advertisement published by your director 24/14, we have to receive any separate application another category of person with disabilities as per existing government law, which separate certificate efforts and for the post of public. That is the position, my lord. So the petitioner as a OBC, he was appeared and last cut off mark is 32. Petitioner got 70 marks. That was he was not for.
You come to your instructions, last line.
Yes. That's so much.
Last paragraph.
Yeah. It may also be based on the.
Yes.
Director of Social Welfare, Assam had appointed 19 number supervisor under C% is the for technical etiquette. There is a total 15. Another person with disability. There are some no candidates selected under the category against
So 2014, you did not appoint, not because they did not submit application. You did not appoint because 2015, you had appointed 19%. So these instructions and this letter are not in sync. The letter at 17.6,
17.6.
you said you did not receive any separate application under the category of persons with disability.
Yeah. They are conducting the
Very right, but your instructions here does not say so. Your instructions which you have received today,
already we have filed a affidavit. But this is a letter
yesterday's instruction says that there was no candidate selected because of the 19 candidates selected.
already.
It does not say that they were not selected because no separate application was received.
And now,
So what is your instruction? Is it this or is it the earlier one?
this one also same.
So this one, that one doesn't tally.
No, no. This is the 19 appointment is.
So better we call your director. It is better we get all instructions from him.
One thing more.
Uh,
It is not claiming as a physically disabled person. The fantasy for a moment impression 7 page 7
Page
7
17.
impression. This is the certificate expired long back. Now he has cured for the fantasy identity card for persons with disability. State code number entity insurance or identity card student for a standard student for dated 6/5/2001.
We are not on there. We are on it is her claim that I have applied.
He claim applied.
You say it is not applied. First you say the records are not here.
They say that at the physical hearing, they say it was applied because this examination conducting authority, they have stated. Now this also, mother, this certificate is not valid. Only for 3 years.
This certificate is we are referring to that particular year. But in the face of your statement saying that none of the persons with disability applied, then this certificate is irrelevant. If you stick to your instructions that none had applied.
This examining authority, they have stated there. Then the no separate was. But it is.
So where are the records?
Records is seen by the vigilance committee.
Digitally, who has the records?
Director.
Director has the record.
Now is the vigilance and anti-corruption department. Under the 2016, there is going to from allegation made. That's why there is no record in us. So by this way, if they are claiming as a matter of property, otherwise OBC, he got only 17 marks. The cut of mark last OBC is.
Why are you making submissions without any factual basis?
No.
Firstly, you don't have the records. You are unable to say whether she is applied or not applied.
On the basis of affidavit. I am saying-
Affidavit, how can it be filed if the records are seized? On what basis have you filed the affidavit?
Affidavit was filed before that.
When was it filed?
Was 95. On the basis of photocopy from photocopy.
Some photocopy you have filed affidavit.
On the basis of some, they have some photocopy.
Mr. Sotia,
Petitioner being a OBC candidate, is not qualified.
you call your director, let us get instructions from him. You are unable to furnish instructions or assist the court. Let us get it from him.
Okay, we have also referred to the order dated 11/12/2020, wherein this was recorded that records have been seized by the vigilance. Therefore, they may take the help of this order and get these records from the authority. 11/12/2020, that order was there. Thereafter, they are beating around the bushes all the time. And just taking time, it is now 2023.
Where is that order?
That order within 11/12/2020 by Honorable Justice. Sure.
11/12.
11/12/20. There are very many orders passed by this one for the whole programs, but nothing has come for. Today. This is making or not happening. And we see this order. Okay.
This order remains 11/12/2020.
Yeah, and then Lordship will find, need to produce before the court. All these documents, relevant, they can.
So we call your director, why he has not complied with this order?
And then 29/9/2021 Lordship will see. Repeated orders were passed. 29/9/2021 by Honorable Justice Levy.
Why don't you read the order? Do you have a copy of the order?
Yes, you can.
Do you have a copy of the order? Mr. Monto, will you please share a copy of the order with Mr. Sotia?
Good, you know, if they didn't score to get back to them, no? We just have to be in the- We have made references in the affidavit that copy was open.
I heard Mr. Learned counsels for the parties. This, in spite of repeated orders being passed, the necessary records relevant for the purposes of the case has not been produced by the learned and examiner advocate on the ground that they are seized by the vigilance department. So we find that as far back as 11/12/2020, this court had permitted the respondent number 2 is what, director? Who is respondent 2?
Number 3 is. Number 3.
Director social welfare.
Right.
To produce a certified copy of that order before the concerned vigilance authorities to get access only to that relevant orders, relevant records, which would be needed to produced before the court, so that copies thereof can be produced before the court, showing the appointment of 3 physically handicapped, physically challenged persons under 3% category. So, in spite of such specific orders, you do one thing. The order dated 11/12/2020 is expected to you. In spite of such specific orders and several opportunities being granted, the respondents have not been able to produce the relevant reports. Are you familiar with this? Have you gone through this order? So, what is your submission? No, regarding this order. Regarding the last order, 1920, what is that order? 11/12 or 12/11? Is showing that copy of that order. See the last paragraph.
I'm wondering, I don't know, it is more than that he told him about the government. Now he is no more.
So in view of such specific orders, we grant one final opportunity to the learned senior government advocate to communicate this order to the department and take necessary actions, necessary steps, if so advised. And by the next date fix. Mr. Monzo, we give him one final opportunity.
My anxiety is, what you have seen, here, the London Council for the department keeps on changing.
No, we are recording his name and we are marking a copy to his office
Yeah,
for taking necessary steps in the matter.
the senior government advocate also appeared way back in 6/12/2021.
We'll mark a copy to him also. Copies of this order be marked to the office of Mr.
What you have seen last time, some Bora appeared, Mr. Bora. Now, thereafter, my friend, Mr. Setia has come. This time, this now, nobody keeps
No,
track.
we are taking.
Nobody keeps track, my lord. I want this report. You take it very carefully.
Copy of this order be furnished to the offices of Mr. Sutiel and Senior Government Advocate as well as to the office of the Senior Government Advocates for information and required action in the matter.
What shall I record? My friends to me. So
We have
this
recorded.
will be in charge.
We have
Every
recorded.
time, he should be.
No, how it would be changed now.
Now, only he cannot say because it's senior government.
He was contacting the
Better, if he takes the responsibility, someone should.
I will
That's why I wrote it, record it.
Mr. Sutia assures the court that he will obtain the required instructions and place it before the court. On the
Otherwise,
next day.
you want to indicate, then there will be no option but to ask the director.
We don't have to indicate, they are aware. We'll pass orders. We are just giving them one final opportunity.
Which you will see the specific order, may not have gone there. Now they have said so. Whether it was communicated or not, who was in charge at that time, what is their record, nothing is there. On some assumption, on verbal submission, that we are working. That is why time is being killed. Every time.
Yes, after 2 weeks.
What can I fix it there?
After 2 weeks. 19th September
19th.
or
Until, are you?
11th September. 11th.
One day. For hearing items 41 to 46.
The party to maybe the outstanding taxing benefit, and the profile I'm representing, I can know 41. And other are like 25. Don't you like need some time to get instruction because when the some amount they have released. Now to what extent will the amount is released and what the figures are there? It is a
2015 matter, Mr. Council.
no doubt. Last question of that there will be this better. And started meeting give the inspection for the old lady that I have already.
Mr. Goswami, what is the standing? You call it? We cannot keep on adjourning matters. What is the amount due? What is the amount due?
There are total 70 numbers of pensions are there. My lord.
No, I mean, in respect of your case,
My lord, that's the my lord. My otherwise, my lord, there is a chart given by them in their affidavit of opposition, 8 lakhs 2,311. And thereafter, my lord, in 12 minutes, they have released certain amount per year. But update.
so they are releasing it, why you want to, why do you want to proceed with the hearing? Let them merely release, you also be happy, let them also be happy. We close the petition,
The thing is that, my lord,
what is there to argue?
the thing is that, my lord, so far the pension amount is undisputed. Only the problem is coming because of their, my lord, the passage of conference. There is a sole issue.
Then
And that is the issue now.
then you have other remedies in law, you take reports to that. We will direct that. If you file it within, if you approach the appropriate forum within a fixed period of time.
That is not a lordship, this one of is already decided that in terms of the whatever pension rules are there, that has to be also applicable in case of present petitioner law. So therefore, they are not, my lord, they are taking a seat.
No, but if it is a crisis of fund, what directions do you want us to issue? They are after all municipal boards.
But,
Whether any proposal has come from the municipal board, department,
That is for devolution fund.
from devolution fund.
So from devolution fund, if they want to do, that is their issue. But that it cannot be that court will issue direction that you pay devolution fund to release the pension.
Time and I think they are informing this.
You have remedies elsewhere. You pursue those remedies. We indicated last time. If they are unable, you proceed. What directions do you want the court to give?
Our only concern is that the pension is to be released.
Correct, correct, but they say that they have no money.
That is been already decided by some court.
Hmm?
That will mean that already been decided by some court.
That's right. Now they are not releasing it. So what are we supposed? We are not an executing court. We'll direct them to release, they will not release, we will file a contempt. What will happen after that?
may I propose one? My lord, after dealing with this matter since 2014, my lord, no doubt, my lord, in per year, they are releasing amount, my lord,
If you are happy with the per year amount, we'll direct and close it, that they will keep on releasing this amount until the total amount required to be paid is to be closed.
Now,
Is
only one thing, my lord, let them place deposit on for a concrete proposal that in each year, how much amount they are inclined to suppose release to the respective petitioner. Then there must be a concrete proposal before.
what is any proposal?
Only matter, they will, on the basis of that fund generation.
Let them get instruction, my lord.
No instructions will come here. No instructions will come here.
Other employees, they are getting the regular salaries, man.
Hmm?
Only the pensioners are not getting.
Hmm?
The working employees, they are regularly getting the salaries.
Naturally, they have to.
Then why not the pensioners, my lord?
You
They are
show us,
really good time, my lord.
you show us in terms of priority. You show us. You see, you are coming before a court, issuing directions that they should pay. They have agreed, yes, we'll pay, but there is a financial crisis. Now you have to. You have to build up your case.
Sir, what happened, my lord, once suppose this matter will be closed, my lord, what will be the solution? Then immediately they will stop whatever they are presently releasing.
Therefore, we are relegating you to the proper forum if you want to go.
What's the policy? My lord, this all, my lord, lady, 70 years old lady will go to the civil court again, my lord.
No, you have, instead of spending here, by this time, some order would have been.
May I propose that let them place a concrete proposal that in each year, in what manner, that they would like to deal with this all persons, matter. Nothing.
You show us that from devolution fund, the pension can be paid. Show us. Devolution fund by the government, the pension can be paid, or they are duty bound to release part of that amount to clear your pension dues.
We can be able to make clear, my lord.
You are relying on which judgment of the court?
No, basically, I'm relying on, my lord, the good finding, lordship findings in the rate petition.
Page 24.
24.
Very clear, paragraph 12, my lord.
Hmm.
Accordingly, it is ordered that pensions, family pension benefit be given to the retired employees, heirs of the retired employees of the board. As the case may be, as per the related Assam rules, which is available to the retired employees, heirs of the employees of the government of Assam, the petition is allowed. Accordingly. Therefore, my lord, it is now, we are now under the, my lord, purview of this, my lord, rules governing, my lord, the pension is, my lord. The question is that, my lord, since our right has been confirmed on the strength of that, my lord, order, which has been passed no doubt, my lord, to other cases, but my lord, since,
What was the order passed in the contempt petition?
my lord, yes, Lordship, I can see the contempt order which has been passed in page 28, my lord. Contempt case is there. And property part is page 28. The petition is disposed of with the direction to the vice chairman, Golpa Municipal Board, Golpa, response number 2. To release the pension of the petitioner within a period of 6 months from today. If suppose that gentleman got that amount, my lord. Now,
This is not your contempt
well,
petition.
another contempt file, page 29 start from, and property part in page 30, last paragraph.
Hmm.
The fact stated above could go to show that though there has been a violation of the court order dated 1/6/1999 by not payment of the amount due to the petitioner, such violation cannot be understood to be deliberate or willful. The violation that has occurred in an account of reasons beyond the control of the respondent, therefore I do not consider it appropriate to pursue the contempt petition any further. The contempt petition shall stand closed, however, the chairman of the municipal board who is also present in the court today and all such persons who may come into the control of the board on subsequent dates shall ensure that the dues of the petitioner are paid in installment from time to time out of funds which the said authority may receive or may be able to generate. The entitlement of the petitioner to prior pension shall also receive similar attention of the authorities of the municipal. Therefore, my lord, the direction is very much clear on that. But based on that, my lord,
No, if the direction is not followed, what is to be done?
my lord, they are following, my lord. We are not saying that each year, my lord, they are releasing funds. This is not, my lord,
But they are saying that depending on the income, supposing next year they don't receive less income.
my lord, each year they are releasing, my lord, installment. There is no reform. One of the thing is that lordship has to not decide. Then,
What is there to decide? That's what I'm asking you.
exactly, my lord.
What is there to decide?
Well, how they would like to entertain? Suppose there must be there must be a plan, my lord, in it. Okay, you take time, no problem. You want to suppose release this payment in case by manner, but you must show something before this honorable court, and there must be convincing answer from their side. Because they are the person who has to release the amount. Might be not in one installment, might be in different installment. There must be certain times.
You show us that from devolution amount, the funds we are entitled to be released, pension.
We need some time, Lord. So what happened actually, we also want to get instruction from my client that whether they are supposed going to continue this process or they want to close this matter by proceeding the alternative remedy. Or executive also want to know that what is the present state of their outstanding. Let the picture be clear, Malik want to Lordship close the matter, no doubt, but they also show before the Honorable Court as on today, what is the actual outstanding amount of the all concerns. Based on that, the Lordship pass whatever order please to pass.
What is the, what happened to this writ petition?
My request.
WPC 2163 of 2009, page number 51. Is it a part of this?
I think it belongs to Senior Council.
In the 2163, 42, item 42.
561, I will raise that matter.
Item 42, some, you order to say.
33.
Then of course, my friends not available. And then there was the next month.
Hmm?
Final outcome, I'm not available.
No, this is the play, this is the resolution. It is still pending. 2163 is item number 42.
Yes.
So this is the final outcome. It is that it is pending.
Yes, yes. So we kindly produce one order of aspiration of recruitment. Order dated 29/2021 in this city member. Well, the meeting is with petitions matter. They don't put my would like to know. Whether any proposal has been changed by the municipal court about that.
For what?
For the purpose of.
Have you sent any proposal? Obviously, they will not release fund. Why will they release fund? What proposal are you sending? They are your employees, there is an order passed by this court, you did not go and appeal against that order. There is a judgment of this court holding that they are entitled to pension. You have not appealed against that. You did not file any appeal against that order. So you are now bound to pay. Direction is to you, not to the government. It's not as casual as that. Contempt case direction, there is no direction. Contempt case has been closed. We can initiate another contempt proceedings.
All that this is better to remove time to time on installment money.
So you continue to pay that amount. We are closing it on that count. What is the amount being paid? What is the amount released every year?
This year we have no.
Already paid, madam. Every month is paid. This is my start.
Your clients are not interested to pursue it. They have not maintained, they have not received any instructions yet.
5 months salary of the parent employees matter to the procedure fund.
Municipal accounts. $62,200.
Yes, control of the government to the municipal board.
want to say. People say that this will go to the authorizations as a government. It's not make any sense. In India, the government has control over the municipal code. And they are also liable to pay the.
Under what provision?
61. 61. Without authorization from the government, they cannot make payment. Cannot control the. Facts of it. Yes, European pension model is result is 50. Subsequent 3.
Section.
Subsection 3, section 50, subsection 3, gratuity or cancel. They are looking, they are saying that the problem from the government.
You have two options. One is to apply for grants and aid for utilization of this fund for other works and for payment of the pension from the amounts collected through taxes, or you create a sinking fund. What is the amount paid by the government?
As per the recommendation of the finance commission,
Hmm.
that is the regulation of the pension there, that is the. That is the thing.
So that amount can also will be a part of the total fund.
That proposal comes from the broker municipal code itself to the municipal administration department. From there to the finance commission. Finance commission recommends. In terms of that recommendation, government takes. No point of time they have. Revenue of nothing has not been paid. That is regularly paid. So all the municipal. Have been paid to the government municipal code. But I am submitting. The repetition. Here they are for directing the corporate municipal code, which is the area pension as well as color pension. That is the prayer, and that has been already executed.
Yes.
The repetition that has been clearly executed. In the two conferences that there is nothing new to execute in this matter, and they are only option to go for the punishment. That is the only option.
What about the proposals that you were supposed to send? Runs in it.
My lord, Nancy, only pay for the partial of the current salary of this kind of.
From where do you say that?
And it is also reflected in the executive whether I said them on the program.
No, but you are the municipality, it is your responsibility. You decide, you tell us from what provision it is to be added. Section 60 talks about application of fund for salaries as well as for pension.
I have filed affidavit, madam, of this.
What do you say in your affidavit?
The affidavit, my lord, I have said that the funds, regarding the pension, no amount has been paid, my lord. And the matter, of course, the generation of funds is very limited matter. So, and the board said, only when.
Mr. Nayak has raised that issue. Yes, nothing is to be left to be decided in the petition.
Nothing has been decided.
Then quantum has been decided. Quantum has been closed.
The Golpa Municipal Board is not acting. They are not sending proposals.
So therefore you file a quantum if you want to file a fresh quantum.
Golpa Municipal Board is not sending any proposal for turning up a pension to the petitioner's manner to the government. For which manner the amount is yet to be paid.
They matter to send the proposal.
Hmm?
And every other provision, the board said, proposal was
Therefore, this one.
I have not with the electric for all.
29, 21. Wanted to know as to what the proposal was said and what the proposal was not said. 29.
The proposal includes what? Does it include pension?
Yes,
So what happened to the proposal?
no, other pay, but excluding that. These are my possibility of taking
Now what have you utilized that other amount for?
Utilized for my the salary of the my current.
But your collection is already there. In these instructions, you have shown that the amount you have collected.
Regarding the my current expenditure, I there page 2 man.
Hmm.
Page 2 man, first part is the amount collection. For the month of May 2023, every month different matter. For the May, 4 lakhs 42,000, 6 are there, 37 is the collection matter. And the expenditure is 12 lakhs 82,266 matter. And they have chosen in what manner they have expenditure on mentioned matter. Labor subjects, wage subjects, street light, sweeper, lineman and fixed payment. These are the matter of the monthly expenditure. They are by the municipal board. And the collection is only by house tax, the room rents, NOC, building permissions. And after my lord, as per my instruction, after my lord, the COVID-19 my lord, so many of the my lord, that is my lord, collection is my lord, more than double that. So the expenditure is more than double that.
Towards the rejection of the grant of the fund, you say it has not been granted to us. Yes, Mr. Sharma, what is, you are appearing in which matter? Where is, who's arguing that matter? It's on the same lines.
Yeah, proposed one thing, my lord, I think, my lord, somehow it is one of them, so, I don't, whatever they can happen, my lord. Let them make it this proposal, my lord, because it is not a case not that government cannot do it, because actually all things are under the control of the government. And based on that, my lord, the finance department, suppose what they would like to say, or the municipal directors want to say something, they must know there are certain reasons for why they are not considering this proposal. Example, that answer will come.
Who appears for the department? Municipal department.
Largely.
What do you say?
Regarding the pension portion, the act itself stated.
No, everything is decided. Act says, judgment says they are entitled to pension. Now, the problem here is that they are required to pay out of their funds. Their funds, they have shown that they have not generated funds. Now, as a department, what do you have any proposal? No. The reason we are asking you is because there is a direction by the court. The court's direction is very specific. They are entitled, pay them. Contempt petitions have not been held to be not maintainable.
Our stand is that procedure, the establishment, and we have submitted, we submitted our existing capability, and services. We got to touch, the principal code. The establishment, the expenditures is to be made out from their own sources, tax, rent, and etc. For releasing of the funds and definitely the budget estimated of the one part and municipal board. And payment of the establishment expenditures, the chairman is solely responsible. The director of municipal administration has no role in this regard.
No, you may not have a role, but you have deep and pervasive control over the municipal corporation. Now, once an order is given by this court, you are required to ensure that the order gets complied. You come back with your instructions with regard to what proposals you can think of. You see, the order remains. So long the order remains, it has to be complied. Department has not gone and appealed, review, nothing. So we cannot permit an order of the court not to be complied with.
The department is agree with the.
Exactly. So if you are not agreed, please act. You cannot sit back with folded arms and say, we are not agreeing. It is the municipal corporation who are not doing. If they are not doing, you being the parent department, you have to ensure how they want to comply. Heard the councils for the parties, give the names. This writ petition has been filed by the petitioner with specific seeking us direction from this court for grant of pensionary benefits and arrear salaries, death cum retirement benefits. What are the amounts you want? Arrear salaries? Pensionary benefits, death cum retirement benefits. In respect of the petitioners who were former employees of municipal board, only one municipal board, Walpara municipal board, and who has since retired. So, the petitioners are employees of so and so or their family members. Yes, you look into the prayers. This court earlier by civil rule number 6261 of 1996 by judgment and order dated 1st of June 1999, held that the petitioners who are employees of the municipal board are the civil rule number so and so, by judgment and order dated so and so, held that the employees of the Goalpara Municipal Employees Union, who was the petitioner, are required to be paid pension as in similar manner. No, sorry, are required to be paid pension or slash family pension as per the related Assam pension rules, and the writ petition was accordingly allowed. Stop. Because of alleging non-compliance of this order, contempt petition number 144 of 2000 was filed, which was closed on 29/8/2001, directing the Vice Chairman Goalpara Municipal Board, Goalpara, to release pension within a period of 6 months from the date of the order. Subsequently, contempt petition number 293 of 2002 was filed, which was also disposed of by order dated 16/2/2004, whereby the chairman of the municipal board was ordered to ensure that the dues of the petitioners in installments from time to time out of the funds which the state authority may receive or may be able to generate be required to be paid. So there are learned counsels for the party submits that although certain amounts have been released every year. However, a substantial amount is yet to be released, and the amounts which are released are also not uniform in respect of the petitioners every year. So consequently, petitioners have approached this court, making with the prayers as indicated above. So the respondents have filed their affidavits. And notice in the matter was issued as far back as 21/9/2015, and thereafter several orders have been passed. So the respondent who have filed, all respondents.
Yes.
The respondents have filed their counter affidavits. So the municipal board has taken a stand that in view of the poor collection generated from the in view of the poor income of the municipal board, which is generated by collection of taxes and fines, etc. The amounts as required to be released could not be released. So it is submitted by the learned counsel for the municipal board that every year a proposal is sent to the government for release of necessary funds, including funds for pension. So although funds under other heads are released, the fund stock for release of grant of pension has not been released as yet. So. Mr. Central Learned Council appearing for the government submits that the direction of the writ petition is in respect of the municipal boards to release the fund. And therefore, the municipal board is required to generate fund and release it. Stop. Having heard Mr. Nayak, Learned Council appearing to the Finance Department, what is your submission?
Is that the board itself, the government of Assam is not liable to face anything when the employee gradually gets the court is to pay the salary from their own source of revenue. This is section 50 of the act.
Mr. Nayak, Learned Council for the Finance Department submits that the department has taken a stand that since the employees are employees of the municipal board, as per section 50 of the act, it is the responsibility of the municipality to arrange for funds and make necessary payments. So there are learned councils for the parties have been heard. Meetings on record have been carefully produced. The provisions of the Assam Municipal Act 1956 has also been produced. Section 58 of the Municipal Act provides for constitution and custody of the municipal fund. Under section 59 of the said act, the municipal board may also raise loans or form a sinking fund. Stop. Section 60 of the act lays down the manner in which the application of fund is to be utilized.
The payment of such contribution to the rate.
Exactly. Under section 60, within bracket A, the fund shall also be used for payment of salaries to the government, to the employees, as well as pension, gratuity, provident fund, leave allowance, as may be required by the conditions of service. Stop. Under such circumstances, it is clear that the municipal board is required to release the funds as directed by this court to comply towards area salary pensionary benefits for the petitioners. Stop. A careful perusal of the provisions of the Act of 1956, Assam Municipal Act of 1956. It is seen that municipalities are constituted under section 4 of the Act. under section 10, municipal boards are created. The various sections of the Act and the spirit of the Act clearly makes it abundantly clear that the government has deep and pervasive control over municipalities created and their functioning. So, under such circumstances, the manner in which the municipalities are being are functioning and the are to be supervised if required by the appropriate department in the government. So this court, by the earlier judgment and order dated so and so past in civil rule number so and so, had specifically laid down the law, and has specifically held that the petitioners are entitled to pension under the state rules. So although the municipal boards were directed to make payments, the same has not been complied with entirely by raising a plea of poor collection by the municipal boards. So, under such circumstances, this court finds it convenient. This court finds it appropriate to direct the municipal board to submit a proposal to the competent department in the government having supervision over the municipal administration, namely, what is the department? Urban development.
Director of Municipal Administration.
Who is the secretary? Is the
principal secretary of some urban,
to the Department of Urban Development Department, to the Urban Development Department. So the proposal will lay down the specific details in the manner in which the amount of pension directed to be paid by this court in respect of the petitioners have been complied with. Will lay down clearly the manner in which the directions of this court are required to be complied with. So this will the municipal board will clearly reflect the amounts already paid and the amount required to be paid. So upon such a proposal being furnished to the municipality, to the urban development department, the department will, in consultation with all other relevant or necessary departments, forward the said proposal to the government for release of fund in order to clear the payments due to the petitioners by way of pension, arrear salary, death cum retirement benefits, or otherwise formulate a scheme in order to ensure that the directions of this court by the order dated so and so passed in CR so and so are complied with. So this proposal will be furnished, will be sent to the so and so department within a period of 60 days from the date of receipt of a certificate copy of this order. So the municipal administration, now what is it, the urban development will thereupon forward the same proposal and work out a scheme so as to clear the funds, clear the arrears of pension and other related benefits as directed by this court. The state exercise by the urban development will be executed, will be completed within a period of how much time? 3 months. 90 days from the date of receipt of the proposal from the municipal administration department. So this order has been passed by this court in view of the fact that the coordinate bench of this court by order dated so and so passed in civil rule number so and so has specifically upheld the claims of the petitioner for grant of pension and directed the municipal board to release pension. So this order has never been appealed against either by the municipal board or by the urban development or any other concerned department of the state. So consequently, this order has attained finality. Once an order of this court has been passed and a direction has been issued, then the same requires urgent and immediate compliance. So, however, in the peculiar facts and circumstances of the case, this court considers it appropriate to pass the orders and directions as above. So, in terms of the above, the writ petitions stand closed.
Possible verification, the department to forward the proposal. Finalization for.
You will have to decide and finalize and formulate a scheme. That way, after finalizing, the scheme will be finalized and accordingly relevant to whatever payments are there will have to be released. The writ petitions stand closed in terms of the above directions. Interim orders, if any, will stand vacated. This will cover all the writ petitions. We'll cover all the writ petitions. Okay, record the names of all councils who are available there.
Only thing that till decision adopted.
Till finalization of such schemes, the municipality will continue to pay the area salaries as is being done in the present.
This pension benefit is
Area salary, pensionary, death benefit as has been done since the direction of the court.
They want to take the exit point, how to not to respond as well.